Yes.
Right, please, Your Lordship. I'm praying for a listing of repetition tomorrow, my lord, due to some urgency, my lord.
Tomorrow.
Yes. Deeply.
Fresh matter.
Fresh. Please.
May I please, Your Lordship? I'm praying for listing of a matter, my lord, in next week, any date, my lord. That matter become influx was that's why, my lord.
Next week.
Next week, my lord.
At
Or
least
this,
in-
sorry, this week, my lord.
Huh?
Friday,
Monday.
Monday, yes, my lord.
Monday.
May I please, Your Lordship, I have to mention for listing, so matter may come up next Monday matter.
What matter?
Content matter in IA was issued a notice, but since long.
13th. 13th.
Published.
May I please, Your Lordship, I am praying for listing this two matter. This is actually, my lord, hearing matter of 17 and 18, my lord. Already matter listed in part 2 list, but this is
Not
not.
which.
Hmm?
Have it on 14th?
14, yes, my. Lordship, I am also praying for listing upon writ petition civil
For what purpose?
for listing.
I know, for what? Admission, orders, hearing,
No, admission.
admission matter. All right, let it come on 27th August.
Similar, Your Lordship, for listing
Admission,
admission, Lordship.
27
But can it be on next week, Lordship?
next week. All right, next week then 13th.
Lordship. Obligation.
Yes.
Therefore, listing two matters for the pensionary benefit admission matter, one content matter. Next week,
18th August.
Mention for listing. One is for pensionary benefits and other is for promotional matters.
18th August.
I'm praying for listing a matter for withdrawal.
Withdrawal
Yes.
tomorrow.
I beg to mention item number 29. I have the consent from the other side. B. Chaudhary is having some personal difficulty today, so he might.
Item number
29. Right?
29.
I'm for the petitioner. 1 week time may be granted, my lord.
29 on the request made by on behalf of Mr. B.
B.
Chaudhary.
Chaudhary.
Matter stands deferred to be listed after 2 weeks.
1 week, man.
2 weeks, 2 weeks. Yes.
One more item, my item number 15, my lord.
Hmm.
I'm for appearing for Disciplinary, my lord.
Hmm.
AP Pathak is out of station, my lord.
Item 15, you have informed the other side
Yes, my lord. Yes,
on the request made on behalf of the council for APDCL. Matter stands deferred, be listed after 2 weeks.
Yes, my lord.
Yeah.
May I please, my lord. My lord, I'm praying for listing of these two writ petitions, which are tagged together, my lord, for hearing, my lord. Can it be on
Let
Friday?
it be for orders.
My lord, it was for hearing, fixed for hearing, and there was a direction to be listed after 2 weeks. So the matter.
Then it will come up in part 2 list.
uh,
If you want to list a matter to be listed for hearing, it should come up for part 2 list.
My lord, can it be come for orders then?
For orders, then you fix a date.
My lord, can it be on Friday, my lord?
Not Friday. 18th,
18 minutes.
18 August.
All right.
May I, Lordship?
Yes.
Lordship, I beg to mention for urgent listing. Urgent listing.
Urgent listing. What is the urgency? Why urgent?
Lordship,
You ask your senior and come back. Yes.
may I present, madam,
Warrant.
contempt matter, my lord. May I present item contempt matter, my lord. May I present item may come up on Friday.
Friday,
17.
Friday would be difficult. Let us-
17 matter.
Huh?
2017 matter.
Very well. He'll have it on Monday. 11.
Friday, ma'am, Monday.
Friday is difficult. There are some difficulties. On Friday, we can have it on Monday, Tuesday, Wednesday, whatever. Monday, 11th.
My please, Your Lordship. Lordship, my prayer for listing an IA, Your Lordship, for order, Your Lordship, to correct, for correction of the
For correction.
implead of the respondent, Your Lordship. Implead.
11th,
So may I pray for on 8, Your Lordship, Friday.
Friday not possible. 11th.
Lordship.
Your Lordship, I beg to mention for listing of WPC 34704.
Can't hear you.
Lordship, listing of WPC 34704 admission next week, Lordship.
Next week.
Monday.
Have it in the week beginning from 11th,
Yes, Lordship.
11th or 13th?
11, Lordship.
11th only.
Obliged, Lordship.
With the consent of the other side, I beg to mention item 6 on today's list. Chief, we're required to file an additional affidavit in the matter on behalf of the petitioner. I'm praying that we may be given a fixed date in this month. because petitioner is retiring on 30th.
Mm,
Otherwise, pleadings are complete.
Item 6, you want to file an additional affidavit.
Lordship, for the petitioner.
Item 6, matter stands deferred to be listed after 2 weeks.
Lordship, I'm praying for a fixed date. It's a challenge to a disciplinary proceeding. Petitioner is otherwise retiring on 30th. So any day
30th of,
this month. Lordship.
can be held.
Otherwise, pleadings are complete.
You have it on 20, 20.
22nd, Lordship.
Huh? 22nd.
22nd.
All right.
My lord,
22nd.
Presence may be marked, my lord. I am appearing for respondents 2, 3, and 4, my. Thank you.
Mr.
PR, sorry.
P.R. Sharma for respondents 2, 3, and 4.
Deeply obliged.
Complete.
May I please your lordship? Lordship, I beg to mention WPC lordship for hearing.
For orders on 27th.
May I plead, Lordship? I beg to mention WBC 29G60/2025. This may be listed after 1 week
After 1 week, you give a date when you want it.
for admission.
Admission. All right, 22nd. 22nd August.
Much obliged.
Yes.
Please, your lordship, this is a prayer for listing of WPC 202 of 2024 for order siege. This honorable court have given the last order as the opposite party needs to submit a reply within 4 weeks, which was back into February this year. And as of date, we have not received any affidavit coming from that.
22nd.
May it please your lordship. Lordship, with the consent of the petitioner, lordship, I beg to mention item 4, lordship. Lordship, here I was supposed to get one order from the department, lordship. Lordship, can it be after a week, lordship? Any date, lordship?
Who's for the petitioner?
I am for the.
Any
On
objection?
that date, your lordship, the particular order where one line was not visible, but they was asked to bring the original one document. So he said that it is not available today with him.
Which is, this is that
The case with regard to
blacksmith,
Yes, lordship.
blacksmith matter.
that
Electrician.
order part, his terms and conditions part, 1 or 2 lines were not visible. Even in our order, it was not there.
When can you get it?
Lordship, can it be on?
We are supposed to dispose of today.
Yes, lord. 14th, lordship. It's a Thursday.
14th. All right, 14th.
That day can be disposed
Yes,
of,
sir.
only that part.
Right,
That
item
part.
Otherwise, I am ready.
to be listed on 14th.
Highly obliged, lordship.
Please, your lordship.
Yes.
With the consent from the other side, I beg to mention item number 19. Finally, the matter may be passed over for the day.
19, the request made on behalf of the petitioner.
Yes, lordship.
Matter stands deferred to be listed after 1 week. Mr. R. Gaur appears for PWD.
Obliged.
For withdrawal, item 34.
Yes.
File a fresh.
On the submission of the counsel for the petitioner on instructions that the petitioner does not wish to press the petition any further. Counsel for petitioner submit, the petition may be permitted to be withdrawn. Accordingly, the petition stands dismissed on withdrawal. Interim orders, if any, stand vacated.
Liberty. Liberty to file a fresh.
Why are you withdrawing it?
If we annex and some more documents, lordship.
Some more documents, you can file it by bringing affidavit. Why are you withdrawing it? No liberty.
For orders, item 1.
This matter, your lordship, practically has hurt. This petitioner was, is engaged from his job on the basis of just one line was issued that there was a criminal case against him. In that case, your lordship, only on the earlier occasion, your lordship wanted whether the earlier order of this honorable court to consider him for regularization was taken up. And there was a specific order. The order did not give any time limit. Therefore, your lordship, we did not find any content. It was direction was made that you cannot terminate the petitioner without consideration for regularization of his service. He was working not for a few years, your lordship. It was more than 15 years. he was working at that particular post. So that is why there was a direction on the basis of a order of the Honorable Supreme Court. So that was the direction. Then your lordship directed them to file a affidavit to bring on record what consideration was done. They admittedly said that there was no consideration done, and an order was passed terminating his service, your lordship. Then your lordship will kindly take the High Court's order at page 29. Here, your lordship, I'll not read the whole order, your lordship, but your lordship will kindly take up page 32.
32.
32, page 32. From here, I'll read it. This part so that your lordship will come to know what has happened actually. Para 4, your lordship, of the judgment. With regard to the said affidavit of respondent so-and-so, filed affidavit of reply stating that he applied pursuant to the advertisement dated for regular appointment to the post of junior assistant. He did not get call letter for interview, due to which he could not appear in the said interview, and this fact has not been denied by the petitioner. Have also brought to the notice of the court that the advertisement dated was for contractual appointment only and not for regular appointment for the post of office assistant, and the petitioners did not apply for the same since they have been regularly working since 2004 and 2007 respectively, and that this fact has also been admitted by the respondents in their affidavit filed on so-and-so. The petitioners have brought to the notice of this court that similarly situated persons were also serving as junior assistant in so-and-so approached this honorable court by in writ petition so-and-so. This court, relying on the decision rendered by Honorable Supreme Court in the case of the Uma Devi, so-and-so disposed of the said writ petition by order dated so-and-so, directing the respondent therein as follows. Considering the matter in its entirety, I am the considered opinion that ends of justice would be met if the respondents are directed to consider the case of the petitioners, taking note of the attending facts and circumstances, more particularly the fact that they have already completed 17 and 11 years of service, and also they have rendered their services in the interest of respondent 3. The cases may also be considered under the relevant scheme for grant of temporary status with consequential benefit of regularization and completion of the required length of service. The matter is left open to the sound discretion of the respondent. It will be appropriate to consider the case of the petitioners with a pragmatic approach till consideration of the case of the petitioners by the respondent in the event that their services may not be dispensed. The petitioners submit that as the case is similar to that of the petitioners in so-and-so, their prayer for regularization may be considered. It is true that the respondent number so-and-one have been working since, petitioner number so-and-so have been working since 2007 in the NEOS Regional Center Guwahati purely on temporary casual design. They have appointed on basis of local selection, but not as basis of selection contemplated in the recruitment rules. It is to be noted herein that as some procedure of regular selection has been followed, their appointment cannot be termed as illegal in terms of the decision of Uma Devi, which are irregular in nature, and irregularity can always be rectified. Considering the period of service rendered by the petitioners and the decision of Uma Devi, this writ petition is disposed of. Directing the respondent herein to consider the case of the petitioners for regularization of the service as observed by Honorable Supreme Court in Uma Devi so-and-so. However, till consideration of the case of the petitioner by the respondent so-and-so in a manner as laid down by Uma Devi, services of the petitioner shall not be terminated further. They shall not be replaced by any contractual or ad hoc appointments. Now, what have they have done, your lordship? There was an FIR, a case, criminal case was filed. In that case, the petitioner was named. He was not arrested, your lordship. He was not arrested. He was only called
He
for.
was not accused. He
He
was not
was
an accused.
named in the FIR. Therefore, he is an accused. But he was not arrested. He was just called to give his statement. This case.
Charge is not filed against him. Charge filed against him.
Yes, yes, sir. Charge sheet has been filed. Your lordship will see the letter at page 63. 63.
63.
In Bhaskar Medi, you are hereby informed that CBI has completed the investigation of the cases noted below, which was registered on so-and-so under section so-and-so, so-and-so, so-and-so against unknown officials of the so-and-so and other private persons. CBI is now filing supplementary final report in the case in the court of so-and-so special at Bhopal. This case is in Bhopal. Page 63.
Yes, yes.
You are hereby directed to appear in the state court on so-and-so as supplementary final report under section so-and-so will be filed against you on this day, particular so-and-so, Bhopal pertaining to FIR, related to malpractice, irregularities in so-and-so. So this was, he was only directed to appear there. He appeared, given his statement, he has come. Now, after that, your lordship, that was issued on 8/2/2021. Now, that was about more than nearly 2 years later on. He was issued a letter that is at page 66. This letter is under challenge. So, this continuation of engagement of so-and-so daily wage. As per office record so-and-so, the office is a receipt of Shibuya inquiry where it has been mentioned that Medi was in criminal conspiracy in a matter of Nios so-and-so held in 2017. You are therefore.
Where is the consideration after the direction of the coordinate bench?
That was not done. That is the case.
That was not done.
That was not done. They have admitted that on the last occasion that last week they have appeared and stated that, and they have also filed the affidavit,
What
which
is
as
their-
per your direction, lordship's direction, and they have not stated that they have considered. Now, after that, your lordship, he was disengaged by this, just one line, your lordship, just that there is a criminal case pending. And this criminal case, your lordship, as per my instructions, that there are more than 100 witnesses and thousands of documents, and it will take a long time, your lordship, for any disposal.
So, what rules govern your services?
In fact, your lordship, in this case, before
You
consideration,
are not regularized.
I'm not regularized still as per the direction. The direction have not been followed. They have just terminated. And one just judgment, I'll just place one judgment. In the case of Pawan Kumar versus Union of India, was it this case? Take on just one paragraph I'll refer. I'll give the citation later. I haven't get this, just now I've got the adjustment. Your lordship, I'll rely on para 30. Para 30.
30
13.
13.
13. In this case, basically, the facts are not totally similar, but it has stated here. Para 13, page bottom right, 6. What emerges from the exposition as laid down by this court is that by mere suppression of material false information, regardless of the fact whether there is a conviction or acquittal has been recorded, the employee recruit is not to be discharged, terminated, or axiomatically from service by just a stroke of a pen. In this case, what has happened, your lordship? There was a conviction of the petitioner, but he did not disclose that in his letter, in his application. That was the case, your lordship. At the same time, the effect of suppression of material information involving a criminal, if any, is left for the employer to consider. All the relevant facts and circumstances as to be antecedent and keeping in view the objective criteria and relevant service rules into consideration while taking appropriate decision regarding continuance suitability of an employee into service. What being noticed by this court is that mere suppression of false information in a given case does not mean that the employer can arbitrarily discharge, terminate the employee from such. So question here is a bit different, your lordship. Here he was convicted, but he did not disclose it. Even then, your court has said that you cannot, without following the procedure of law, at least your lordship 311, or at least notice, and an inquiry should be conducted if there is to be on the punitive ground. Otherwise, if your lordship, the consideration part has not been done, since that part itself, your lordship, this matter goes in favor of the petitioner, that there was a direction for consideration, you have not considered, and then you have passed an order where nothing has been stated, just because a criminal case, your name is there. You may be acquitted, your lordship. Nobody knows. It's just his name is there. He went there. He was not even arrested. If he had been arrested, he was in custody for more than 48 hours. Then something else could have been come. But now just one. And the court says in para 13 itself, you cannot just, in a stroke of a pen, dismiss or terminate a service in a
This
particular
is on a
person.
different footing because you are not regularized.
Not regular. That is one aspect, but there was a direction that you cannot be terminated. That is why I am placing that. There was two directions. One is consider for regularization, two, you cannot terminate without.
Why was it not
So
considered?
that part itself.
Why was it not considered for, in terms of the order of the court?
No, my lord, affidavit I have filed, my lord. As per the instruction, my lord, their stand is that because these are engaged through outsourcing and agencies, my lord. But what I have seen in the writ petition, my lord, this is completely different, my lord. It was engaged as engaged as by the department itself, my lord, not as outsourcing and agencies, my lord. So it's.
I'm polarizing naকি আওয়াজ কমিয়ে দিল, বড়াই দেব না না বলবো। Yes.
As per the stand of the respondent 5, my lord, shows that the petitioner was appointed to outsourcing agencies, my lord. This is their stand in this petition, my lord.
Then you should have approached the court seeking clarification of the
Now,
order.
my lord, what I have seen in the writ petition, my lord, he was engaged by that NIOS itself, my lord.
Where is your appointment order?
That is at page. There is no specific order as such, you know. See, this was given page 19, you know. See. In daily wages. And based on daily.
He was employed as what?
As daily wages, man. He was appointed as grade 4. And he's in page 21, he's been shown as peon. Then this part, your lordship, with regard to the daily wage, that has been, your lordship, indicated in the judgment of the honorable, this coordinate bench of this honorable court, your lordship.
Where is the averment that they have not considered the case in terms of the judgment? You said there is an admission.
They have stated in there, they have not stated. When your lordship has queried and asked them to file the affidavit, in the affidavit, they have not indicated they have considered, your lordship. Just a moment, your lordship, I must have. Page 82, my lord. I have additional left. Yes, para 13, we have indicated that it has not been considered for regular.
In your reply.
No, in my writ petition itself, at page 11, para 13, I have stated.
No, you have stated, but you
Yes.
said that it is admitted in their affidavit.
They have not stated anything with that regard when they were asked to file the affidavit. And on the last occasion, when your lordship queried, they said that there was no instructions in that regard. And that page 82. Paragraph 2, 82 here. 82, 1. In para 2 of their affidavit, they stated. They did not state they have considered.
Yeah, where is the order of termination again?
That is at page 66. 66.
Who represents this gentleman, Assistant Director?
The department.
I have communicated all, but no inspection. Till that I have not received any inspection.
No, this page number 66. Assistant Director Personnel is what? Is Assistant Director of,
No, I'm reading it. He is
Which
the
department?
respondent number 6 here in the writ petition.
who represents respondent 6?
6, I am appearing for respondent 5 minor. 6 approved.
I am from.
Was
So he is
this, was the earlier order of the court not communicated?
I have communicated, madam, but no response.
No
One, two-
response.
No response. Till date.
Heard. Mr. Y. S. Manan, learned counsel for the petitioner. Mr. Your name,
J. Lashkar minor for respondent
A
number
law score for respondent.
5 minor.
Only 5.
5 minor.
Only 5. And Mr. P.S.
But it's a
Bhattacharya for,
1, 2, 4 and 6.
you have not received any input from the department?
No,
Nothing
nothing.
from the respondents 1, 2, 3, 4, and 6. The petitioner before this court was engaged as a grade 4 daily wage worker under the National
National
Institute
of Open Schooling.
Open Schooling Regional Center, Guwahati, Bamni Maidan. So, in view of certain criminal proceedings which had been instituted against the petitioner as well as other employees of the National Institute of Open Schooling, petitioner was not regularized, and in being aggrieved, he had approached this court earlier by filing WPC 1648 of 2011. By order dated 24/5/2017, coordinate bench disposed of the writ petition, directing with the following direction: para 7, para 8. So, in spite of these directions being there, the same were not complied with, and the petitioner had been directed to be discontinued from his engagement by communication number so and so dated 29th of November 2022 by Assistant Director within bracket personnel. Stop. This communication was sent to the Regional Director of National Institute of Open Schooling Regional Center, Guwahati. So, pursuant thereto, the petitioner was disengaged. Stop. He filed representations before the authorities concerned. However, these representations remain unanswered. Stop. Aggrieved, the present writ petition has been filed. Pursuant to issuance of notice, the respondent number 5 filed an affidavit with the averment that he was instructed to disengage the petitioner by communication dated 29 November 2022. As a consequence thereof, the petitioner was disengaged. 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 The petitioner was disengag Stop this disengagement letter was disengagement order was issued as the petitioner was involved in a scam and the CBI is investigating the matter. Stop. The other respondents have not filed any counter affidavit, although the opportunities were granted. Better. Upon considering the submissions made by the counsel for the parties, and upon careful perusal of the order dated 24/5/2017, it is seen that the direction to the respondent authorities was to consider the case of the petitioner for regularization of his service in terms of the directions given in Uma Devi, reported in so-and-so, as well as the directions contained in the order dated 3005/2012, passed in WPC 1382 of 2004. So, it was further directed that the services of the petitioner shall not be terminated till the consideration of his case by the petitioner, by the respondents, in the manner laid down in Uma Devi Supra. Stop. It was further directed that they shall not be replaced by any contractual or ad hoc appointees. Stop. From the pleadings, from the averments made in the pleadings as well as the submissions made, it is seen that it is seen that the respondent number 5, in its affidavit, that it is seen that there is no averments in the affidavit filed by the respondent 5 that the petitioner was given due consideration in terms of the directions contained in the order dated so-and-so, passed in WPC so-and-so. So the only averment is that the petitioner was instructed, the respondent 5 was instructed to disengage the petitioner and by the who has instructed director personnel, assistant director personnel, by the communication dated 29th November 2022. Stop. The other respondents, in spite of opportunities being granted, have not filed any affidavit. Stop. The counsel representing the respondents number 1 to 4 and 6, Mr. Bhattacharya, also has submitted before the court that he does not have any instructions from the said respondents. And under such circumstances, this court considers it appropriate to consider issuance, that issue a direction to the respondents, more particularly respondents number
5, because he's the
respondent 5 and 6 to remain personally present in court on the next date fixed, along with all the relevant records of the case, in support of their actions stated to have been carried out in response, stated to have been carried out against the writ petition. Failure to comply with this order will entail consequential orders to be passed by this court. Let the matter be posted again on on 8th of September. Copies of these orders be marked to Mr. J. Loskar, counsel appearing for respondent 5, Mr. P.S. Bhattacharya, learned CGC, appearing for respondent 1, 2, 3, 4, and 6. It is made clear that the respondents will remain present in court at 10:30 on 8th of September, along with all relevant records, along with their counsel. List accordingly.
All right. Obliged.
For orders, item 20.
In this case, Milord, I am appearing for respondent number 2, 3, and 4, Milord. We are going to file affidavit today itself.
None represents the petitioner. Mr. S. Kotoki, learned counsel, submits appearing on behalf of respondents 2, 3, and 5.
4, Milord.
2, 3, and 5. 4 submits that you'd like to file the affidavit within 2 days
Well,
from today. You are appearing for petitioner.
Yes, on behalf of myself,
Who is your sir?
PM Talukdar.
PM Talukdar. Say, MS so-and-so appears on behalf of Mr. PM Talukdar. List after 3 weeks.
Well,
Item 2. Wait.
Your lordship, may paid with last order dated 26/9/2024, my lord, and we have sought for a report from the director of IS, my lord. But that report we have not received, my lord. So I spent some time. Today also they will issue a reminder, my lord. Your lordship, may paid with order dated 26/9/2024, my lord. That order was passed on the basis of this communication. The matter was placed before the cabinet, my lord. Cabinet took it.
This is the report.
This is not a report. This is regarding the placing of the matter before the cabinet where this proposal was.
Where is the office of the director Ayush?
My lord, here it is.
Where? Here.
Here, this food, my lord.
Then why is it taking so much of time?
My lord, that's why today we are issuing a reminder, my lord.
You are not doing this order is of the 9.
Yes, my lord.
You will let us call him. What reminder?
My lord,
Let us call him.
a date may be given.
What
thereafter.
date may be 1 year? You are sending a reminder after 1 year, Mr. Bora? You
No.
are referring to an order of September 24.
Yes, my lord. No,
And you are now informing the court that you are going to issue a reminder today.
no, in the month of June also, my lord, there is a communication.
Therefore, let us call him if he has not responded. Why is
No,
he
my
not
lord.
responded?
Let us issue a reminder. once
We
my
want
lord.
your report by Monday. Get it on Monday or we call him.
My lord, actually, on the basis of this report, my lord, there may, the department may take a decision as per the proposal by the cabinet, my lord.
You have pointed out an
Yes,
order.
my lord, that is true. But
It
Monday,
is,
my lord.
your submission is recorded here,
Yes, my lord.
26/9, isn't it?
Yes, my lord.
Your submission is recorded here. that you have received some letter and is requested to submit a report. You have been granted time. Subsequently, further time.
That is on the basis of the cabinet decision, my lord. We have sought for the
What
report.
is your grievance here?
Grievances, my lord, the petitioners here in the faculty members of homeopathic medical college, my lord.
They are the
Homeopathic medical college faculty members there. And they are claiming the AICT pay scale at par with their counterpart in allopathic and Ayurvedic. In fact, my lord, the homeopathic physicians are granted the pay scale at par with the allopathic and Ayurvedic physicians. And in fact, my lord, health department has agreed to that. It is the affidavit of the health department, it is the administrative department, that they have sent the proposal to the finance, but finance is not clearing it. That is their statement.
Where is their affidavit?
They quit. It is filed on 26th of February. Lord, paragraph 5. Paragraph 5 of the affidavit of health department. It is signed by one Subroto Roy Bardhan. It was filed in the year 2018. Paragraph 5, Lordship will page 2 of the affidavit.
Yes.
Paragraph 5, Lord, that as regards the statements made in paragraph 3 of the writ petition, the deponent begs to admit that AICT pay scales are granted to the faculties of nursing, dental colleges, along with pharmacy institutes, in addition to faculties of medical colleges and government Ayurvedic college. The Health and Family Welfare Department had submitted proposals to the Finance Department for granting AICT pay scales to the faculties of homeopathic medical colleges of Assam, particularly those who have obtained postgraduate qualification in homeopathy. Next, paragraph 8, my lord, that as regards the statements made in paragraph 8 of the writ petition, the deponent begs to state that in pursuance of letters as annexed in Annexure B and C of the petition, the government of Assam equated diplomas with 4-year study course with the degree by government letter such and such. Then paragraph 13, that as regards the statements made in paragraph 14 to 20 of the writ petition, the deponent begs to state that the matter of implementation of Pay Anomaly Committee 2010 for granting AICT pay scales to the faculties having postgraduate qualifications in homeopathy is being earnestly followed by the Health and Family Welfare Department. The department requested the Finance Department to accord approval concurrence for granting AICT pay scales to the faculties of homeopathic medical colleges of Assam, particularly those who obtained postgraduate qualification in homeopathy. The file has been returned from the Finance Department seeking certain clarification. As such, the file is under process in Health and Family Welfare Department for meeting the clarification and for doing the needful. It is a 2018 affidavit.
Then what clarifications are you are required to furnish?
My lord, that is.
Finance has sought for clarifications. You have not given them.
No, subsequently, if lordship comes to this letter dated 21/9/2024, just now one letter was produced.
The letter that I have produced before your lordship.
Lordship, in that letter, lordship,
Hmm.
from the middle portion, to further justify. So it was a decision of the government. To further justify the proposal, it was suggested that IUs first take steps to improve the functioning of the newly amalgamated homeopathic colleges, specifically in terms of both academic performance and patient services. Only after these improvements are made should the enhancement of pay scales be considered at later stage. Subsequently, last paragraph, lordship, one report was sought for lordship, and the health department was directed whether that report was furnished or not. So that instruction only.
Why is it not being furnished by the director Ayush?
No, furnished or not, that instruction not yet received.
He is not received. He says we are sending a reminder. Why has it not been furnished?
My lord, now also I have communicated with the department. They have not received the report, my lord. They are issuing a reminder to them. my
No,
lord.
no. Who is Ayush is under which department?
Under the MERT department,
Then?
Medical Education and Research Department.
Then you represent respondent 3 also.
Yes, my lord, both higher.
Then why the report has not been furnished?
That's why, my lord, I need.
We'll have it on Monday. You get the report. Tell us.
My lord, by Monday, I can apprise your lordship regarding the status, but report, I am not sure whether they have prepared or furnished or not. But I can apprise your lordship.
Then you inform us at 2 o'clock today.
Monday, my lord.
Find out from this director why the report has not come. And when it is likely to be given.
By Monday, my lord. Because today I am trying to communicate, but I could not communicate direct with the director, my lord. I have communicated with the department, my lord. Monday, my lord, I will.
All right,
apprise-
Monday, 11th. Third Council for Parties, Mr. D.P. Borak, Standing Council Health, submits that the report sought for from the Director Ayush has not been received, and a reminder is likely to be issued during the course of the day by the Department of Health and Family Welfare. Mr. Nayak, Learner Additional AG representing Finance Department, submits that clarifications were sought for by the Finance Department from the Health and Family Welfare Department, but the same are still awaited. As a consequence, the AICT pay scales claimed by the petitioner could not be processed, has not been processed. So, from the case records, it is seen that as far back as 26/9/2024, the Council for Health Department was required to furnish the report, was permitted time to furnish the report from the Director Ayush. Stopped. Consequently, let the matter be listed on 11th, on which date the Learner Standing Council will apprise the court about the status of the report required to be furnished by Director Ayush. Stop. List on 11th.
Much.
Item 3.
Lordship, I'm praying for some accommodation in this matter as we are the newly engaged counsel. We'll be filing our wakalatnama today.
Yes. MS
M. Tiwari.
M. Tiwari, counsel for the petitioner, submits that they have been recently engaged in the matter. They are yet to complete their instructions. Therefore, let the matter be listed again. She prays for 3 weeks' time. NSA Gayan appears for the CGC for the respondents. Does not object to the prayer made. List after 3 weeks.
Item number 5.
They have completed our argument, my lord. They needed some instruction, my lord.
We'll have to refresh our memory. It was completed here.
Yes.
Before this court.
Yes, my lord. 10th of June, my lord, your lordship has additional AC Barboda appeared for the petitioner. One written submission also, my lord, I have given. Last occasion.
You are working as operator, data entry operator, copyist, peon, chowkidar.
In Foreigners Tribunal,
Foreigners
we are the supporting staff.
on a contractual basis, getting a fixed remuneration.
Fixed remuneration, 10,000 and 9,000. We have been selected by this honorable court. The selection process was initiated with the High Court. My lord, we are all.
Now you are aggrieved by non-enhancement of your pay.
Our claim is that we are entitled for entry-level pay scale of the post we are serving, my lord, as per the decision of the Supreme Court and our High Court, my lord.
Where is the order of the monitoring bench?
Monitoring bench, my lord. Page 118.
Lordship, may kindly see 119. This monitoring bench, my lord, I am submitting, my lord. On the direction of Supreme Court, my lord, this monitoring bench took up the matter. This case was taken up, my lord, 1754 of 2015 to consider all the grievances and difficulties faced by the foreigners travelers in Assam, my lord. So time to time, monitoring bench passed the order. Lordship, may kindly see 119, page 119. Now it shows, my lord, the supporting staff strength, my lord, UDA, LD, for each foreigners travelers, my lord, these are the supporting staff.
No,
Like-
no, we are asking you, there is according to you, there is an order of the monitoring bench.
There are many orders of monitoring bench. That's why I'm coming to one after another, my lord.
Ah.
Finally, my lord, the state government took up the matter with the government of India, because here the salary is paid by the government of India through reimbursement system. So the state government took up the matter with the government of India to grant us the minimum scale. And by the last order, the government of India has passed an order saying that they are not giving this because this is a temporary appointment. That order we have enclosed, madam. The last order, Lordship, may kindly see of the monitoring bench, page 136. On the seventh line from top, my lord, with reference to the earlier order dated so-and-so passed by this court, so-and-so has produced a communication dated 28/8/2023, issued by the Under Secretary, Government of India, Ministry of Home Affairs, addressed to the so-and-so, whereby the proposal for payment of regular salary and allowances to the supporting staff connected with the foreigners travelers in Assam have been declined on the grounds stated in the said order. Since the question of payment of regular salary and allowances and regularization of services of the supporting staff of the foreigner staff is a matter concerning their individual right, and the court is of the opinion that the said aspect of the matter would not fall within the scope of the ambit of inquiry by this monitoring bench. As such, without expressing any opinion on the letter written so-and-so, the court hereby observes that individual employees may agitate their grievances, if any, on the above issue by instituting an appropriate proceeding. So as per this order, my lord, we have filed this writ petition, my lord. And the impugn order, the order which has
The monitoring bench was looking into the enhancement of scale and all that.
my lord, regarding the members, there's a finding of the monitoring bench that this is really not proper, that their scale is, they are entitled to have their enhancement. That is it. But when our enhancement was declined by Government of India, monitoring bench has passed the order, says that the Government of India has declined it. Now you can pursue this is your personal right.
That's all right. But what was the monitoring bench monitoring? What was it monitoring?
So for our aspect of the matter, it left with us, say that you have to institute a proper proceeding for this. Ought to have, my lord, this issue ought to have been taken up by the monitoring bench, my lord.
Yes.
My lord, monitoring bench, the order of the monitoring, that is page 136, that monitoring bench clearly stated, if, my lord, kindly say, as such, without expressing any opinion on the letter dated 28/8/2020, this court hereby observed that individual employee may agitate their grievance, if any, on the above issue by instituting appropriate proceeding, if so advised, my lord. But my lord, they are not entitled for pay scale, my lord. Because initially their appointment was fixed, kindly see page number. Madam, first of all,
We
that
want to know what was the monitoring bench,
look up.
what orders in respect of your enhancement were passed?
This is the last order when the
Initially.
Initially, yes, madam. Yes. That's why, my lord, I was coming to the orders passed by the monitoring bench. (121), Lordship, may kindly see for a moment, my lord. Though it's not 121. This order is 19/1/2023. Last paragraph, my lord. This is regarding members, my lord. You can see the members of the foreigners travelers who were recruited in so-and-so and so-and-so have been rendering continuous services for several years, and their tenures have also been extended by the government from time to time, it is quite natural that they would have legitimate expectation that there would be periodic review and enhancement of their salary analysis. The other government employees serving in various departments are given increments from time to time. Therefore, with the rising level of inflation and increase in the cost of living, such a request coming from the members of the foreigners travelers cannot at all be brushed aside. So this is regarding members. So far we are concerned, my lord, page 124. One 124, my lord, we made a representation to the authorities to give us the entry-level scale, my lord. The PUC 1 is the representation, 124, my lord. The PUC 1 is the representation that is so submitted by some employees who are working on fixed pay on various foreigners travelers in Assam, making a prayer for granting them benefit of the regular pay scale. PUC 2 is the representation that is so submitted by so and copies so chokidars working in different foreigners travelers, making a similar prayer so. So our matter was taken up when we raised the grievance, my lord. And 131, Lordship may kindly see. It starts from 130, my lord. Heard Mr. H.K. Das and Mr. So learned amicus curiae appearing in the case, and also heard D. Mojumdar, learned additional advocate general appearing for the state, who submit that the proposals have already been sent to the Ministry of Home Affairs, Government of India, for conversion of pay rule of the members of the foreigners tribunal as well as the supporting staff from fixed pay to scale pay. The matter is now pending before the Union Home Ministry. Then next 133, my lord. Second para, my lord. In terms of the order dated so passed in this case, Mr. Nath has produced copy of the communication dated so as to indicate that the remuneration of learned members of the foreigners travelers coming from advocate background have been enhanced from so to so. So members, it was enhanced, my lord. Per month, 1,000 so has been raised to so. However, insofar as the remuneration of the supporting staff is concerned, the learned departmental council had prayed for some time to obtain instructions in the matter. Now, thereafter, this Government of India passed this order, my lord. That 136 I was reading before your lordship, my lord.
Where is that order?
My lord, yes.
Where is that order passed by the government of?
Yes, my lord. My lord, I have enclosed, but there is a type copy, but fair copy will be on a original copy is page 203, my lord. They have enclosed, my lord. This is under challenge, my lord. I am directed to refer to Government of Assam political
Page
203, my lord, of the paper book, my lord.
203.
My lord. May I read it, my lord?
Yes, this is to the Chief Secretary.
My lord, to the Chief Secretary, Government of Assam. By the Government of India, my lord. I am directed to refer to the Government of Assam Political B Department letter number so and letter number so on the subject cited above, and to say that the representation dated so as mentioned in the order dated so in WPC number so has been examined in consultation with the Ministry of Home Affairs. In this regard, it is stated that while requesting for creation of additional temporary 64 FTs and posts therein by DO number so dated Government of Assam has specifically proposed creation of supporting post to DEO driver, copyist, office peon, chowkidar on contract basis and and accordingly refer the proposal to Ministry of Finance, Department of Expenditure for concurrence as proposed by Government of Assam. While granting approval for creation of 384 posts in regular pay scales for 64 additional temporary FTs, DOE specially stated that the work of remaining post of DEO, copyist, peon, driver, and chowkidar may be managed through outsourcing of services. Accordingly, Ministry of Home Affairs had directed Government of Assam to manage supporting staff through outsourcing the services on contractual basis by letter number so-and-so dated so-and-so on fixed pay as indicated therein. However, it is observed that the Government of Assam engaged this supporting staff directing on contractual basis through advertisement. This advertisement was issued by the Guwahati High Court, my lord. Since Government of Assam had proposed creation of this supporting staff on contract basis and they have been engaged on contractual basis against temporary posts created for the additional temporary FTs and their services are purely temporary in nature and not governed by the rules and regulation applicable to the regular government servants. It is not feasible to grant regular pay scale to these temporary supporting staff engaged on contractual basis. So basically, Government of India says, my lord, we are on contractual basis. That is not in dispute. We are not saying anything. We are not asking for regulation also. Only thing is that Government of India is saying that we were engaged in a temporary post and therefore this cannot be, my lord.
Now, what is your status? I mean,
We are continuing all this. There are at present there are 100 FTs, my lord. There are 100 FTs, my lord. They are giving the.
but you are not regularized.
No, regulation is not our claim here also, my lord. We are contractual. That is not in dispute.
And what is your claim for enhancement under what provision?
Under what provision, my lord, will be relying on the Supreme Court judgment, my lord. It says that if we are working the same duties like data entry, embroidery, copies, chowkidar, peon, we are working, my lord, then we are entitled for data entry, entry level scale. And our High Court observation, my lord, one judgment and two judgment, my lord. My lord, we are all qualified. We are not daily wager like that, my lord. We were recruited by an advertisement process initiated by the High Court.
We want to know, this court wants to know what is your status of engagement. I mean, how many years have you rendered your service?
From 2019, we are working.
19. You are working on temporary engagement. Contractual engagement. And there is no scope for regularization.
Because the tribunals itself are temporary, my lord.
That's why, my lord. That's why contractual, that were contractually accepted. In the same advertisement, Lord, you may kindly see for a moment, my lord, the advertisement. But what disparity has been, there is also a ground, my lord, page 71.
Yes.
They are giving 9,000, 10,000 to us. My lordship, kindly see paragraph 72. Eligibility and selection for the post of UDA cum accountant. In the same FT, my lord, the scale they are getting, my lord, pay scale has been mentioned. Next, my lord, it is a post of LD assistant, bench assistant, and typist. They are given scale. Next, my lord, the stenographer, pay scale is given.
You are appointed as what?
Right side, my lord, right side. My lord, we are appointed as data entry operator, 10,000 per month. Qualification, then, my lord, copyist, it was mentioned 6,000, but finally it is given, my lord, 9,000. And then eligibility and peon, chowkidar, my lord, it was mentioned 6,000, but 9,000 is given, my lord. So basically, they are getting 9,000, 10,000, my lord. In the same.
In the advertisement, is there anything for enhancement of?
No,
My lord, there is nothing.
Nothing, my lord. My lord, foreigner staff tribunals are functioning in this state for last 45 years, my lord. Considering the condition, how they can say this is a very temporary thing. It is not making a bridge or a dam, my lord, that engaged today and after 6 months will be fired. How outsourcing, my lord, how the Government of India said that we should be, this post should be outsourced. This is being done in a very temporary measure, my lord.
Yes. And what is the government stand?
And our stand is page number. Page number 196, my lord. Case number 190 letter dated 2013. Before setting up of the tribunal matter, that is approval of the Government of India, kindly see page number 197, paragraph 3, my lord. It has also been agreed that following supporting staff may be managed through the outsourcing of the service on the contractual not exceeding the amount indicated below. That is the approval of the government of the India, my lord, before that this advertisement. And my lord, kindly see. And on that ground, my lord, we have passed the order that is page number 1203 dated 28/8/2023. Initially, our approval for this staff, my lord, driver copies for contractual through outsourcing, my lord. And my lord, advertisement was published by the, that is in page number 72 by the High Court, my lord. But the High Court is not made a party in this petition, my lord. And they approached before the High Court also, my lord. Kindly see page number. They gave representation. Page number 116.
No, but the funding is to be released by the central government.
Central government, yes, my lord. Funding is released to the central government.
What has High Court being arrayed as a party got to do with it?
My lord, but advertisement is as
Maybe
condition of the advertisement.
This
my
is
lord,
not their case that in the advertisement, some conditions were there that have not been complied with. It's a simple case of enhancement of pay parity.
So our initial approval for these staff members are for that contractual basis or through outsourcing, my lord. So these are the payment, my lord, and we
That
have,
was at a time when when these were initially set up,
yes, my lord.
and there was no
But my
clear
lord,
indication for how long it has to be set up.
no, that is not clear. That is temporary basis. That is, they also admitted, my lord, in their petition also that tribunals are temporary in page number.
Not temporary, all right. They are not asking for regularization.
Yes,
They are
ma'am.
asking for proper pay scale.
Pay scale.
You are giving pay scale to other appointees in by the same
Yes,
this communication.
yes, my lord.
There are other appointees like typists. What is the difference between a typist and a data entry operator?
And my lord, as per advertisement, they submitted their application, my lord, and they accepted the condition of my lord service, my lord. Because in the advertisement there is a pay scale for this person, my lord, and they have accepted that, and they have submitted their application, and they applied for, and they took the service also, my lord, as per this advertisement, my lord.
Yes.
This has been addressed by Supreme Court, my lord. There is no option, my lord. I say that I'll not accept this pay is not, and now there is scale is not given. Supreme Court has, I'll be relying only one judgment, my lord. Judicial, my lord. That has dealt with all the cases of the Supreme Court, my lord. Lordship may kindly seek for a moment, 169. Our High Court decision, my lord. The point your lordship just pointed out, 169. One case was filed by Rupjuti Das Bhuya. She was contending for a long time on. Has the lordship got it?
Yes.
My lord, I'll be reading the second, third paragraph, my lord. The letter also refers to the order dated so-and-so of the Government of India in the Ministry of Home Affairs while approving the proposal of the Government of Assam for setting up 64 tribunals, additional temporary foreigners tribunals in the state of Assam, and has also agreed for creation of the posts like UDA cum typist, UDA cum accountant, LD assistant, bench assistant, stenographer, grade 4, so-and-so. However, so far as the post of copyist, data entry operator, driver, office peon, and chowkidar are concerned, who were integral part of the functioning of the foreigners tribunals, the letter provides for their contractual appointment on fixed monthly remuneration. The logic behind is not understood. If the foreigners tribunals are really to be made functional, the importance of copyist, data entry operator, driver, office peon, chowkidar, etc.
What happened to this matter after all?
But yes, next page, madam. It was granted by this honorable court. So you kindly see 171. This is the final judgment. Here, my lord, paragraph 6, Lordship kindly see that judgment I'll be relying upon, my lord. My lord, State of Punjab versus Jagdish Singh. That has been relied upon. 176, my lord. Accordingly, the writ petition stands allowed by directing the respondent authority jointly and severally, especially the respondent number 2, to send the proposal to the finance department for extending the minimum scale of pay to the petitioner within an outer period of 2 months, which includes the time for interdepartmental communication and so on, so on. And Lordship may kindly see, my lord, their own guideline on this point, my lord. Lordship kindly see 214 and 217.
What happened after this? This was complied with?
It was complied with, my lord. He got everything, my lord.
My lord, in this case, my lord, kindly come to page number 173, my lord.
Hmm.
Paragraph 6, my lord.
Yes.
By referring the decision rendered by the Supreme Court of India in the case of State of Punjab versus Jagjit Singh, that is so, which was referred to in the case of Upendas, the learned Center for the Finance Department submitted that in the said case, a findings returned by the Supreme Court of India that there should be a party in the pay and that it was on the basis of the principle of equal pay. The said decision was rendered on us and the persons claiming the party to establish he was rendering the same service which was being rendered by the another service. Now kindly come to Ballot. Paragraph 8, my lord. In respect of the point raised by the learned syndicals of the finance department that there was no universal application of the criteria of the cutoff of the 10 years of the service which would entitle a person to the benefit of minimum scale pay in the case of Upendas. In this regard, court is of the considered opinion that in the decision of the case Upendas, it referred the benefit of extended to those persons who had rendered 10 years of service at that point of time. They have already rendered 10 years of service, but these are the 2019 appointee, my lord. In this said case, the court did not pass general order to command the respondent to extend the benefit to all persons who are similarly situated. Nonetheless, the benefit was extended to the government to all the master role workers, fixed pay, casual worker who at the relevant time of that completed 10 years of service, my lord. But in this present case, my lord, they were appointed in 2019, my lord. And on the basis of that, the honorable court, my lord, allowed this petition, my lord. And regarding, my lord, 214, my lord, our notification.
Well, 214 may be seen, my lord. Their own stand, my lord. Own circular, Government of India, my lord.
214.
214 and also, my lord, there is another latest one, 217.
Hmm.
My lord, that Lordship kindly see clause Roman 5(4), where the nature of work entrusted to the casual worker, it is casual worker, my lord, and regular employees is the same. The casual worker may be paid at the rate of 1/30th of the pay at the minimum of the relevant pay scale plus DNS allowance for working 8 hours. So, my lord, the casual worker, they are being paid on daily basis. To say that minimum scale for that regular post is to be divided by 30, and whatever the outcome, that should be the daily wage, my lord. In a way, it says that the entry-level minimum scale should be given. This is in consonance with the Supreme Court judgment, my lord.
No, but then you have to read serial number 1, 2, and 3 also.
My lord, persons on daily wages should not be recruited for work or for regular nature. Then recruitment on daily wages may be, we are not daily wages, my lord. We just, my lord, daily wages may be made only for work which is casual and seasonal or intermittent in nature, or for work which is not of full-time nature, for which regular post cannot be created. The work presently being done by regular staff should be reassessed by the administrative department concerned for output and productivity, so that the work being done by the casual workers could be entrusted to the regular employees. The department may also review the norms of the staff for regular work and take steps to get them revised if considered unnecessary. But our position is better than this, my lord. Regular and casual workers, they don't need any qualification. They are not selected through any process, my lord. We are qualified people, and we faced a regular inquiry, selection process initiated by this honorable court. After being selected, we are being appointed, my lord. And many department has data entry operator, many department has copyist, And peon and chowkidars are in almost all departments. Their work cannot be differentiated manner. I have enclosed the ROP, my lord. Page 113 may be seen, my lord.
No, this OM,
Well,
you are relying on this OM.
yes, my lord. This is also why do we mean to say
You are
that
referring to clause 4 only.
4, my lord. And then, my lord, it has been updated. Annexure 17, page 217, my lord. Where the nature of same thing, my lord, work entrusted to the casual worker. Here it is casual worker. Our position is much better than that, my lord. And the regular employees is the same. The casual workers may be paid 138. The principle is that if you are getting the same work being done in a temporary measure, my lord, you must pay the entry-level pay scale, my lord. Now, Lordship, may kindly see for a moment, my lord, page 113, my lord, for a moment. What the regulars are getting, my lord. This is, in a way, my lord, exploitation, my lord. One one three. This is the ROP I have enclosed, my lord. Categories of staff common to all departments, to the departments. These are common copies, my lord.
This is State Department.
Yes.
State ROP. This payment they are getting around. My instruction is that they are getting around 34,000 per month copies. Peon Chowkidar Mali, my lord, they are getting 30,000 around. We are getting 1/3 and less than 1/3, my lord. And the earlier page, my previous page, my lord, 112. Data entry operators, they are getting the higher payment, my lord.
Let us come to the judgment of the coordinate bench.
Which judgment, my lord?
Judgment you refer to in
Yep.
case of some other similarly situated person.
171, my lord.
Your hours. Where is the advertisement again?
My lord, that is
71.
71, my lord.
What is the significance of para 3 of the judgment, page 172? There was some communication by which the name of the petitioner was not forwarded.
Paragraph 3, my lord. The learning counsel for the petitioner submitted the despite communication dated so and so. Political answer, the name of the petitioner was not forwarded to the respondent before, and therefore her name was not being approved for granting minimum scale of pay.
Who forwarded the name of the petitioner?
Well, this petitioner is a different petitioner. She was also working. This is not anybody from this our case, madam.
We're not on that.
Madam.
Respondent.
It appears that
Yes,
there was a step taken by the government,
Madam.
perhaps by the state government, to
Madam.
forward the names.
Number 4, members foreigner tribunal.
Hmm?
In this case, madam, foreigners tribunal. Members foreigner
Therefore, her
tribunal.
name was not approved.
She's not a foreign member, she's a copyist.
But
Copy.
her name is, madam, page number 171. Here it is written, my lord. Name was not forwarded by respondent number 4, my lord.
4.
Respondent 4.
Respondent number 4. That is in page number 171.
Member.
Okay. No, it is required to be forwarded. What is the procedure, which is what I'm trying to understand. What is the procedure? Who is to forward the names and to whom? Is there a procedure that requires the member to forward the names? That these are the persons who have been retained? So there is some communication issued by the political department 21/6/2019.
Yes, madam.
Where is it available here?
No, madam. Yeah.
What is this communication? What is the procedure, madam?
The procedure for
Procedure for retention of the post, payment of salary.
payment of salary, my lord, central government released that amount to the
On
state
what
government.
basis? There must be some proposal.
Yes, my lord.
Yes, my lord.
Proposal is, my lord.
201 maybe.
Who
seen,
sends
madam.
the proposal?
In our case, my
State
lord.
government sent a proposal, my lord.
Ah.
Then on the basis of that proposal, central government released the fund, my lord.
201
Total
maybe.
is to
seen,
the- For all the tribunals, my lord.
201.
1, my lord. State government took up the matter, my lord,
Hmm.
to the Ministry of Home Affairs, my lord. So far, our case is concerned. To
Yeah.
convert it to scale pay from fixed pay, my lord.
And
No,
that
no.
is not the general.
This is on a different issue.
Yes, my lord, this is not.
Under paragraph 2, my lord, may we mention that the department has earlier written to the Ministry of Home Affairs and so with request to consider the revision of current remuneration structure of the supporting staff working in the foreigners tribunals across Assam from fixed pay to scale pay.
Mr. Counsel,
My lord.
you are coming before a court urging your right.
My lord.
You have to show us where is your right. You want a direction from the court, you
My-
must crystallize your right.
My lord.
That this is your right to be considered for grant of scale pay or equal pay.
My lord.
The benefit of Upen Das will come only after you complete 10 years.
10 years, my lord.
Then,
But Upendas
like Jagjit Singh, then somebody has to decide on this issue that there is equal work for equal pay. But what is the procedure? What is the procedure for release of your funds, retention of your of the persons? Since the funds are released by the central government, there must be a proposal.
This proposal has been sent by the time by
Where is that proposal in respect of the petitioners?
that may be sent by the central government is can say but.
It will be available with the central also because you've released their funds.
Yes, ma'am.
We want to see what is the proposal for. Is it an annual proposal? Is it a periodical proposal? What is it?
My lord, subject to correction, my lord, this communication I am reading 201, my lord. Kindly see, state government took up the matter because it is
No,
being
state government took up the matter to request the central government that convert it to a
scale pay.
scale pay.
My lord.
They have rejected.
They have rejected. Now,
Ah.
that's why I am before your lordship, my lord. The reason that has been given, your lordship kindly see, there are two parts of the reason, my lord. One is this a contractual. There is no dispute that we are contractual. We are not asking for regularization. The second thing, they are saying that we are not doing it because this is a purely temporary need.
Exactly.
My lord.
To justify that, there must be proposals that it has been retained year after year after year. Therefore, the understanding of the central government that this is a temporary post is incorrect.
And not wrong. It is year after year, my lord.
We don't know, you have not placed the proposal.
Yes,
Is
my
it a one-time proposal?
Not one,
Is-
that I'm sure that is not one time proposal.
They must be sent somewhere because see, your, the, you are challenging this 203, isn't it?
My lord,
203.
my lord.
So this 203, according to them, these are supporting staff
My lord.
and they are to be engaged temporarily.
Well.
Now, on what basis they have returned a finding like this? It must be on the basis of some proposal.
That one order has been recorded by the my lord monitoring bench. That we have taken up the matter and the letter I have placed before lordship. Pursuant to that only, my lord, Government of India said that we are not
It's all right, but monitoring bench is not, has released this matter.
delegated the matter to us, my lord.
So now you're agitating your claims.
Right.
To agitate your claims, you must crystallize your right. What is your right? What is your right to say that you have to be given a scale pay? Essentially, you're asking that.
My lord, if your lordship, my lord, I submit, my lord, our right is fully founded on Jagdish Singh, my lord.
Jagjit Singh judgment. If you go through Jagjit Singh judgment, there are various aspects there.
Various aspect, my lord.
So in order to examine all these, there has to be a direction to examine all that.
My lord, that has not been done. If your lordship pleases, my lord, that can be done, my lord. Like, and also that Government of India circular, my lord. Government of
You
India
are
circular.
praying for a direction to the central government to examine your case in
But
terms
that
of
will
Jagjit
delay the
Singh.
matter, my lord. Only again I have to come again. I have to come, my lord.
No.
Now,
What we are trying to understand, what is your prayer?
my lord, no, my lord. That consideration they have rejected. Now, whether they should consider Jagdish Singh, they should consider their own circular that I pointed out. That
To satisfy me, we will pass orders that they should. There is no scope for consideration.
My
We
lord.
have to release the amount.
My lord, my lord.
But for that, we need to see. You need to crystallize your rights.
My lord.
You are referring to Jagjit Singh, but that is the law. But what is there on the facts? How have you been retained?
My lord, fact
Is there
of the
any
case,
proposal sent?
my lord,
Are there any proposals sent
by
for retention of these posts? Must be because you are temporary posts. Contractual posts.
proposal sent from state government to Government of India.
We don't know that. We are
That-
asking you.
That I placed, my lord. Your lordship, my lord.
Where?
State government took up the matter, my lord.
Where?
And that I'm not possibly.
That is on a request to make it a scale pay.
That is all. That is the thing which you are asking from this honorable court, my lord. You are praying for, my lord. That we should get,
Show us Jagjit Singh.
my lord.
Yes, let us see.
What is question? What is question?
Jagdish Singh, my lord, last occasion, I furnished a copy, my lord.
We'll have it, don't worry.
Hard copy was given, my lord.
Yes.
Can you give us the citation?
My lord, SCC citation is, my lord,
Hmm.
2017 1 SCC 148.
Yes, please.
State of Punjab versus.
Yes.
My lord, it's a voluminous judgment, my lord. I'll just refer to the relevant paragraphs, my lord. Paragraph 7 to 41, the Supreme Court has considered all the judgments, my lord. That I'm not referring, my lord. It's a voluminous. Then paragraph 42 is the parameter of principle of equal pay for equal work.
Hmm. So show us the ratio of the judgment.
My lord. Paragraph
Yes.
my lord, paragraph 51.3. Considering everything, my lord,
Yes.
for all the above reasons, we are of the view that the claim of the temporary employees for minimum wages on a par with regularly engaged government employees cannot be declined on the basis of the judgment of so and so. So there was a judgment contra to that, my lord. So that, and paragraph 56, the main thing starts, my lord. Onward. We shall now deal with the claim of the temporary employees before this court. There is no room for any doubt that the principle of equal pay for equal work has emerged from an interpretation of different provisions of the Constitution. The principle has been expounded through the large number of judgments rendered by this court and constitutes law declared by this court. The same is binding on all the courts in India under Article 141 of the Constitution of India. The parameters of the principles have been summarized by us in para 42 herein above. The principle of equal pay for equal work has also been extended to temporary employees, differently described as work charge, daily wage, casual, ad hoc, and contractual, and the like. The legal position regarding the temporary employees has to be summarized by us in paragraph 44 herein above. The above legal position, which has been repeatedly declared, is being reiterated by us yet again. In our considered view, it is fallacious to determine artificial parameters to deny fruits of labor. An employee engaged for the same work cannot be paid less than another who performs the same duties and responsibilities. Certainly not in a welfare state. Such an action, besides being demeaning, strikes at the very foundation of human dignity. Anyone who is compelled to work at a lesser wage does not do so voluntarily. He does so to provide food and shelter to his family at the cost of his self-respect and dignity, at the cost of his self-worth, and at the cost of his integrity. For he knows that his department would suffer immensely if it does not accept his dependents would suffer immensely if he does not accept the lesser wage. Then paragraph 60, my lord. Last paragraph. Having traversed the legal parameters, we refer to the application of principle of equal pay for equal work in relation to temporary employees, daily wage employees, ad hoc employees, employees appointed on a casual basis, contractual employees, and the like. The sole factor that requires a determination is whether the employees concerned before this court were rendering similar duties and responsibilities as were being discharged by the regular employees holding same or corresponding post. This exercise would require an application of the parameters of the principles of equal pay for equal work summarized by us in paragraph 42 above. However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to record the factual position. We say so because it is fairly acknowledged by the learned counsel representing the state of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were also available in the regular cadre or establishment. It was also accepted during the course of their employment. Temporary employees concerned were being randomly deputed to discharge duties and responsibilities which at some point of time were assigned to regular employees. Likewise, regular employees holding substantive posts were also posted to discharge the same work which was assigned to the temporary employees from time to time. There is therefore no room for any doubt that the duties and responsibilities discharged by the temporary employees in the present set of appeals were the same as were being.
There is one particular aspect. I do not know whether you have appreciated this or not. You see, your appointment is that of copyist.
Yes, data entry operator, copyist,
Copyist. Now,
4 posts.
data entry operator, copyist, office peon, and driver.
Chowkidar, my lord.
Chowkidar. Now, if you look into the other posts, which are
Given scale.
UDA, LD, bench assistant, stenographer,
Madam.
these are all scale pay.
Madam.
Right? Now, it is not your case that your work and their work are one and the same.
No, or not. We are not saying that we are entitled to that skill. We are not saying. We are saying that the post we are appointed to, the same post, there are other people working in other departments, as I have pointed out, your lordship. That scale, the data entry operator appointed in other departments, maybe state government, maybe central government, that skill may be given. We are not asking for the stenographer thing.
So, where is the evidence you have laid out to say that the work performed by the other data entry operators and copyists in other departments and the work done by you are one and the same?
My lord, this is not being denied by them at any point of time.
It's not a question of denial. The judgment you are relying on is squarely on the case of similar work, parity of pay, parity of employment, depending on the work, nature of the work you have undertaken. These matter, in these cases, there are two sets of employees doing the same work, regular and contractual, daily wage, etc. They're doing the same work.
In our case.
In Jagjit Singh.
Jagjit Singh.
So therefore, the claim is that we are doing the same work.
No.
Why this artificial differentiation? Here is a case where you're asking for a scale of pay.
Entry level scale.
It is not your case that there is a set of regular data entry operators, copies, etc. They're getting scale of pay. Their work and your work are one and the same.
Now, Jagdish Singh says that the same post, but you kindly see, we are not engaged as simply contractual laborer. We are not engaged as daily worker or casual worker. We are engaged as a specific, giving a specific nomenclature. Data entry operator, copyist, peon, chowkidar.
So where is the finding by any authority to say that your work and the work done by other data entry operators?
That is something cardinal in making a prayer for equal pay for equal work. That I understand, my lord. My lord, that to that extent, my lord, that what work we do, that computerized working, copying, everything, my lord, that we are working as data entry operator in the same service. That is
the communication by the state to the central government, which came to be rejected, is not on this ground. It is conversion from fixed pay to scale pay.
Fixed pay to scale pay.
There is no justification that this fixed pay to scale pay is required to be done because your work and the works given by other similarly situated persons in other departments are one and the same.
Malad, peon working, Malad, chowkidar.
That is your submission. You will have to bring out the.
Malad, that should come from their reply or state reply that no. They are doing works of the menial nature, Malad. They are not doing that same work being done. There is no denial. They are only saying these are temporary posts. Nowhere in the pleading and document it has come from their side that no, we are doing some manual work. So the data entry scale we are not entitled for. Our appointment is giving a particular nomenclature to the post, not as a casual worker. Here, my lord,
if you go, you are relying on Jagjit Singh, therefore we are raising this.
It's a pertinent point, my lord.
Jagjit Singh has laid down the factual matrix. That these are the people working regular, these are the people on contractual labor, but they're doing the same work.
When Jagjit Singh says that there is no submission from the authorities that these people are not doing that regular nature of work.
Exactly, but there has to be a proper evidence laid before the court. We are not on that. We are not pressing you to bring the evidence. What we want to know is that there must be some document, some proposal by the department to say that your services are necessary for functioning of the tribunals.
That I have the observation of the court, my lord. The cadre, that my lord, monitoring bench, my lord, they say the supporting staff cadre has been laid down, my lord.
All right, who's for the home department? Can you give us any proposals which have been sent to the central government, state government for retention of their posts, their salaries, etc.?
Lordship, in our affidavit and at annexure 4, Lordship, that it only speaks of the
Affidavit
Invitation.
by respondent,
Page number.
home and political. Yes, paragraph.
Lordship. 13 and 14, Lordship. Paragraph 13, Lordship, with regard to statements made in paragraph 15, 16, and 17 of the writ petition, the deponent begs to state that the representations dated 16/2/23 and 17/2/23 submitted by the petitioners were marked to the Government of Assam in Political B Department, and rather on receipt of a communication from the Deputy Secretary to the Government of India Ministry of Home Affairs by letter dated so-and-so, the state government collected and provided a copy of letters, the representations, Lordship, along with copies of correspondence made between the Government of Assam and Ministry of Home Affairs in connection with the petition submitted earlier by fixed pay employees of Foreigners Tribunal for granting of scale pay to the Government of India for consideration by letter dated 11/8/2023. 14, Lordship, the deponent begs to state that foreigners.
Do you have the orders of the Supreme Court directing establishment of tribunals? Please get them. It is available. There are several orders.
Additional.
Additional.
Or the initial.
Initial. Where are you working?
They are additional.
Both. No, both additional and regular.
All at 20.
There are total 100 now.
Ah,
Thereafter, another 100 was created. That has been dissolved.
yes.
Now only 100. Out of 100, my lord. Coming, my lord. Out of 100, my lord, 34 are regularly created in 1985.
You give us the original, the orders of creation.
85. 1985, it was first created, and 64, another 64 was created in 2014. So total 100 are operating in Assam, my lord.
Can you give us these orders?
No, my lord, I'll get, my lord, creation of Foreigners Tribunal.
There are orders by the apex court.
Well, so far the 85 is concerned, I don't think, but 2014, that additional 64 was created. Maybe that.
2014. 14 orders.
Mal. In all, my lord, these tribunals are functioning for last 45 years, my lord.
No. This advertisement is for what? This is for how many tribunals? Which tribunals?
17.
This was initially for a period of 2 years.
2 years, my lord. Now it has been extended time because this is.
No, these are for inclusion in which of the tribunals?
My lord, I'm coming to that. 71.
These are additional.
Additional.
No, only FT it is mentioned, my lord. Foreigners Tribunal.
In case number 195, my lord, MHA referred a proposal for setting up additional temporary 64 tribunal, my lord.
These are still in existence.
Yes, my lord. Some are
Yes.
existence, my lord.
All are in 100 are in existence, my lord. Where we are working now.
Page number?
Case number 195, my lord. For additional. This is until May 2026. May 2026. Is it possible? My lord, May 2026. সেইটো কাৰণে extend কৰি থাকে। মই সেইটো হেৰি কৰিছিলো ন। My lord, this tribunal are extended till May 2026, my lord. Yes.
Yes.
My lord, these tribunal are extended time to time, my lord. That's initially they were extended for 1 year involving the creation. Now it is extended up to 2026.
Where is that extension order?
Extension of the gift, my lord, I have to promise. Then I have to get status, yes.
You don't have this extension order?
They may be having.
एसी को बंद कर दिया क्या? क्यों? है दूसरी कोई?
My lord, one Tripura Division Bench or Tripura High Court order, my lord, Division Bench order on the same issue, my lord, is also relying Judicial and another High Court, Supreme Court decision, my lord.
You are not giving us the facts first. We are clear on the law. There is no problem with the law. Give us the facts. How your posts are created, how they are retained, who has given the proposal. There has to be a sequence. If you want a direction from us to reconsider, we
No,
can
no, my lord,
close it.
that would
As simple
not-
as that.
My lord.
Please get it.
Yes, ma'am.
Heard counsel for the parties for further hearing on. We'll keep it on 14th.
On a hearing, day, my lord.
Hearing, yes, 14th for further hearing. The counsel for the parties are permitted to place on record the orders, relevant orders of the apex court as well as of the high court regarding the creation of the additional. I will not use the word additional, you say the relevant tribunal in which the petitioners are presently employed, and the proposals, if any, forwarded by the government of Assam for retention of their posts. Let these information be placed before the court on the next date fixed.
Item 7.
Yes.
Arbitration matter, my. And this matter in piecemeal has been heard on many occasions. So without what I am going to submit, my lord, he has challenged why the arbitration is not to be allowed, my lord. Appointment of the arbitrator is not to be allowed only on two grounds. First of all, there is no existence of any agreement.
There is no existence of?
Any agreement, because the agreement has become void as soon as he retired from the partnership firm. And second, that there are the allegations of fraud. These are only the 2 points, my lord. So far the first point is concerned, my lord. It has already been decided by the Honorable Supreme Court and different High Courts that merely for the reason that the agreement is declared illegal or void or non-issue, even though the arbitration clause survives. And in that aspect, I have referred the many judgments, my lord. And the recent judgment is the interplay between arbitration agreements, my lord. Now the next question regarding court, my lord. For this purpose, my lord, may I come first at all to the Arbitration Act, my lord.
What are the disputes?
Disputes regarding because you misappropriated the fund of the partnership fund, and that's why we want to refer the matter to arbitration as per the court.
You are, who's Sandeep Nahata?
He is one of the partners.
You are representing?
I am Sandeep Nata.
You are representing Sandeep
Yes.
Nahata and you are representing Kothari.
Kothari. He is the other partner who retired.
Now, according to you, Kothari has misappropriated certain amount of money.
Yes.
Now, against that, you have filed criminal matters.
Not criminal FIR.
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 It has not been charge sheeted.
No question, my lord. And these allegations are the simply sheeted, my lord. Because those are allegations so far for the purpose of prosecution is concerned, my lord. Those are to be proved beyond reasonable doubt, my lord. First at all. So far the arbitration is concerned, it is entirely.
We are asking you a very simple question that after lodging the FIR, what is the status of the investigation?
Investigation is pending, my lord.
Pending.
No further use.
No further invest.
We are on bail. We are on bail.
You are on bail, but no charge sheet, etc. has
No
been
charge.
filed. And is there any civil suit also pending?
No.
No.
Had there been the civil suit, the question could have been a different one. So that is
So why are you objecting for appointment of an arbitrator?
My lord, as my senior has rightly pointed out, there are two grounds on which I have been objected. First of all, an notice has been sent because it is an arbitration. Sorry, my lord, it is a partnership at will. There is no time limit mentioned in the this agreement of partnership. The lordship will kindly see page 14 of the petition. Page 14, commencement and duration. Serial number 3.
Has it been dissolved?
Yes, my lord. By virtue of section 63.
Of?
Section 63 of the Partnership Act. Because it is a partnership at will, so I have resolved after this.
Any communication to that effect?
Yes, my lord. Yes, this notice your lordship will find 43(1), my lord. This is page 27. Page 27. It was dissolved under section 43(1). Lordship got page 27.
Yes.
This is the notice under section 43(1) of the Indian Partnership Act.
Page number?
Page 27.
27. Yes.
I have given this notice to the petitioner herein, page 28. Because he has lodged some affairs with false allegations and all, that has to be adjudicated of misappropriation of money. And he has not allowed me to participate in the partnership business. I have issued this notice. And page 28, last paragraph.
Yes.
Under the circumstances, I being one of the partners of Messrs. Swastik Agro Products, dissolved the partnership by issuing this notice under the provisions of section 43(1) of the Indian Partnership Act 1932 from the date of receipt of this notice by you. Further, I hereby give you notice to settle the accounts of Messrs. Swastik Agro Products immediately upon receipt of the notice, failing which I shall not be responsible for financial transaction of the dissolved firm. Now, he has replied to this notice. It's a strange reply, page 29. May I just read out the reference? With reference to your aforesaid notice, whereby you have expressed your desire to retire from the firm by virtue of your right under section 43(1). If your lordship kindly see the provision of section 43(1), what does it say? 43(1) of the Indian Partnership Act. It says dissolution by notice of partnership at will. Where the partnership is at will, the firm may be dissolved by any partner giving notice in writing to all other partners of his intention to dissolve the firm. So there is no question of any retirement. So in his reply at page 29, he says, desire to retire from the firm. I would like to intimate you that in spite of the fact that the provisions contained in section 43 of the Indian Partnership Act are unqualified, however, such unilateral decision is always subject to settlement accounts, discharge of liabilities, and apart from above, your rights and obligations continue notwithstanding the dissolution and complete transactions begun but unfinished at the time of dissolution. Therefore, I request you to come forward, settle the accounts, discharge your liabilities and obligations. By issuing the notice under section 43(1), while dissolving the firm, I requested him to come forward and settle the account. And in his reply, he says your retirement from partnership firm is unwarranted, unqualified, and come forward to settle the accounts. Now, he had made some allegations of misappropriation of accounts and all. Now, kindly see the notice, which is very vital for appointment of an arbitrator. Notice invoking the arbitration clause, which your lordship will find at page 32. This is also notice dated 29th of November 2024. It is addressed to me. I'm skipping first page. I will take your lordship to page 34.
Yes.
Paragraph 3. That during the year 2023, you on behalf of the firm purchased master seals containing in bags, and their payment thereof was made even on weight of such bags. The weight of bags came to so-and-so kilograms, and the value of their master seals came to so-and-so. In view of the aforesaid fact, the master seals of the purpose of manufacturing oil and cake come lesser by so-and-so kilograms, according to the information of the undersigned and the procedure and practice followed in purchasing master seals. The value of such bags ought not to have been paid to the sellers, and in fact, the value of thereof was not paid to the sellers, and difference is rupees so-and-so amount, which was misappropriated by you by taking cash from such sellers. However, the said quantity was shown in as damaged master seals, but such damaged seals were not available in Godown. Similarly, you did mischief during accounting year 2023-24 in respect of such and such kilogram of master seals amounting.
So there is some dispute.
Yes. Not only this, my lord, I will take your lordship to paragraph 5, page 35. Not only against me, there are some numerous other persons. I don't know who they are. Paragraph 5. That similarly, payment of salary of to various staffs numbering 19 total during the year of 22-23, you misappropriated a sum of rupees so-and-so by showing excess payment to staff and taking back cash from them. Avinav Kumar, factory staff's actually salary was so-and-so, but he was paid sometimes so-and-so, sometimes so-and-so, and sometimes so-and-so. Excess amount paid above so-and-so was taken by cash by you, and you kept the money for your perusal use. Car driver, Devendra Roy's name also came. Then below that, Samarjit Nath's actual salary.
No, that's all right. Now, what do you want to submit with regard?
My lord, this is an allegation of fraud, which is not as simpliciter as my senior has submitted. It's a question. This question of fraud is a complex one which cannot be adjudicated by an arbitrator. It's competent civil court is the right forum to
You
it.
have not, have you filed any criminal cases against
No,
him?
no, I have not filed.
Then
I have
it
not
is not
filed.
your case that not you, but he in turn, on the contrary, has
No, I have
resorted to fraud.
that's true, my lord. He has earlier filed an FIR.
Why can't an arbitrator decide whether these allegations
Not a-
against you will stand or not?
Not only these, my lord, these are the some names, and page 37, your lordship will find several other names.
Whatever it may be.
So
But where is the bar for an arbitrator? Where is the technical bar that an arbitrator cannot go into this and resort? You have also asked for settlement of accounts.
yes, that
Then
is
how-
true.
If both of you don't get together, how will the accounts be settled?
That is true, but
If you,
this
if
is
you
not
don't want
before
an
the arbitrator,
arbitrator,
because
if
this,
you don't want an arbitrator, you go and settle the accounts unilaterally on your own.
that's what not happening between the
So
parties.
therefore, an arbitration.
My lord,
And you have agreed to an arbitration in the agreement.
my lord, that was in my humble submission in a Gujarat High Court's judgment. It says when a notice under section 43(1) has been given, the parties cannot be forced to go for arbitration.
That is contrary to apex court.
My lord.
Apex court will prevail.
But
In
that
that lay
apex
between
court only under section 8 of the Arbitration Act, 9 of the Arbitration Act, but not in such a situation where the partners are.
Apex court, subject to correction, the principle is that the arbitration agreement has to be treated to be an agreement different from the
independent.
agreement.
It's
separate and
several.
It has
That
to
is
be
true.
severe.
But where this entire agreement, partnership agreement is dissolved,
That's
partnership
right.
is dissolved.
So if that principle is applied, then it is separate. Then even if you dissolve, the arbitration part remains.
My lord, that is true. And the second question is the question of arbitrability of this type of fraud elements.
This will also be decided. We have rendered judgments that
Yes.
even the arbitrator will decide whether these are arbitrable or not. This is not a case that there was no agreement, nothing. Maybe somebody,
But
or there is a contention that there was nothing in writing, but you verbally agreed. Therefore, you have been forced to arbitrate. Now, even the question of, even if you are not a party to the arbitrator,
that can,
whether you can be referred to arbitration.
that is true in one of my cases.
Therefore, the attempt is to resolve disputes out of court by alternative dispute resolution.
Exactly, my lord. But the judgment of AISME that speaks that that was upheld in several other judgments, subsequent judgments. That says when the question of element of fraud is such a complex.
There is an allegation.
Yes.
There is an FIR is filed. There is no charges or criminal proceedings pending against you.
That is pending. That is pending.
He says no charge sheet has been filed.
Not yet. Investigation is still going.
Investigation is going.
Yes.
It has not returned a finding that these charges prima facie are correct against you.
No. There is a thing, my lord.
And alternatively, you have not filed any counter allegations or made counter allegations against him.
I have not made any allegation, my lord. Page 58 of my affidavit, my lord.
58.
58. After lodging this FIR, before I was sought for PRS bail, the police has given this memo.
This is for The investigation is not complete.
Yes.
So does it require an arbitrator to proceed in the arbitration when there is no?
There is absolutely no bar in
There's no bar.
proceeding through parallel civil and court. But the question only in my mind, it comes whether these allegations, whether the disputes has raised are simpliciter of fraud or not.
That the court will have to look into. There is a judgment passed by this court.
Minor.
That even arbitrability of disputes can be looked into by the arbitrator. This can be heard before the arbitrator.
Minor. That can be done. With that observation, your Lordship may refer it to the arbitration.
What is that judgment arbitration? No. তার পিছনে একটা judgment আছে। এই arbitration or judgment যে আছে এটা পারিবা নাকি চাই ওলাই দিব from our talks? Yes, Mr. Bhatti, what do you want to submit in respect of?
The arbitrator may kindly be appointed.
Which part of the judgment you want to refer to in interplay? Paragraph?
My lord. Paragraphs 98, 105, 109, 119, 122.
98,
98, 105,
105,
109,
109,
119,
119,
122,
122.
235.5.
Huh?
No, 122, man.
122.
Yeah. Interplay. Interplay between arbitration agreements.
Very good. ওলাই দিও এটা প্রিন্ট আউট এটা ইয়ার পিছনে এটা সাবসিকুয়েন্ট জাজমেন্ট দিল।
Well, I was relying upon the ISMS case.
You are relying on?
2016-10 SCC. 386.
Did you furnish any? No. If you have a copy. This is for what proposition? And
My lord, this is regarding the fraud simpliciter. Paragraph 22 and 22, 23 and 25. 24 and 25.
My lord, I also rely upon those paragraphs. I also rely.
You also rely?
Yes.
On the same judgment?
Of the same judgment, simpliciter. Because and this question can only be decided.
That has to be decided case like.
And the last one, my lord.
We are going one by one, we'll come back. Any judgment on section 43? The Partnership Act
43, yes, my lord.
vis-a-vis arbitration?
Yes, my lord. And 98 Gujarat High Court. Because
You are not alleging you are not disputing the existence of the partnership deed.
no,
It is not your case that it is by fraud these signatures have been obtained, nothing like that.
nothing. But my case is that I have dissolved it prior to invocation of arbitration. Paragraph 6 of that Gujarat High Court judgment.
We will come to it. Hmm. Is it on a mere allegation, or there has to be a finding by a court of law that there is some fraud?
It has.
Hmm? How do you distinguish fraud simpliciter
That is true.
Because these are only the allegations.
and
which
serious
are
fraud?
wrong. These are only the allegations, man. And so far the criminal case is concerned, that
Do you,
is
do you have
entirely a
do
different
you have a
case.
copy of the judgment?
Which one?
I.S. Swami? I.S.
Yes.
Swami?
I have.
You have?
I.
Kindly come to para 23.
Para
23.
23. Yes, madam.
23 onwards.
Yes. Before we apply, may I read
Yes.
24?
Yes.
Before we apply, the appropriate test to the effects of present case.
No, no. 23.
23. A perusal of the appropriate two paragraphs bring into force that the law commission has recognized that in cases of serious fraud, courts have entertained civil suits. That is regarding the civil suits, my lord. Civil suits. Secondly, it has tried to make a distinction in case where there are allegations of serious fraud and fraud simplicity. If thus follows that those cases where there are serious allegations of fraud, they are to be treated as non-arbitrable, and it is only the civil court which should decide such matters. However, where there are allegations of fraud simplicity and such allegations are merely alleged, we are of the opinion that it may not be necessary to nullify the effect of arbitration agreement. Between the parties, as such issues can be determined by the arbitrator. My lord, it is a mismanagement, whether there was the misappropriation of fund or not, and those relates to the accounts money. That can only be properly done in.
No, we are asking you what is the difference between serious fraud and fraud simpliciter?
Serious
Allegations.
Serious fraud means, my lord, which affects the public at large. Which affects the public at large, my lord.
See, para 23 has a reference to allegations of serious fraud.
Yes.
Or fraud simpliciter.
Simplicity. Simply, we have made the allegations, my lord, merely the allegations.
So whether these allegations are
Yes,
serious fraud or fraud simpliciter?
it is the fraud simplicity still the under investigation, whether the police will take, will file the charge sheet against me, or they will seek the final report for discharge of the accused persons. So
If
that
you-
it is still, it is simplicity, nothing has been decided, man.
If your lordship kindly see the notice to appointment of arbitrator, page 37 onwards,
Yes.
whether
Misappropriation, the words
whether these
misappropriation,
are
we have
fraud
used
simpliciter or
fraud and misappropriation merely by using the word fraud. It
No matter.
doesn't mean that it is
several
serious fraud.
names of several other persons have been mentioned, page 37 onwards.
No, my lord, other persons with whom he transacted and whereby he misappropriated the fund.
And my lord, FIR was lodged not only against me, but also against my brother also.
That is a different question. The arbitration is not against his brother, my lord.
Now come to para 35.
35. Yes, ma'am. Ordinarily, every civil or commercial dispute between whether based on contract or otherwise, which is capable of being decided by a civil court, is in principle capable of being adjudicated upon and resolved by the arbitration, subject to the dispute being governed by the arbitration agreement, unless the jurisdiction is excluded either or by necessary implication. Thus, this court has herein such and such adjudication of certain categories of proceedings is reserved by the legislature exclusively for public fora as a matter of public policy. Certain other cases, though not exclusively reserved for adjudication by courts and tribunals, may be by necessary implication is excluded from the purview of private fora. This court set down certain examples of non-arbitrary disputes such as disputes relating to rights and liabilities will give rise to or arise out of criminal offenses, matrimonial disputes relating to divorce, judicial separation, restitution of conjugal rights and child custody, matters of guardianship, insolvency and winding up, testamentary matters such as the grant of probate letters and succession certificate, and eviction of tenancy. Eviction of or tenancy matters governed by special institute where a tenant enjoys special protection against eviction and special courts are conferred with the exclusive deal with the dispute. This court held that this class of actions operate in them, which is a right exercised in civil at large, as contrasted with a right in personam, which is an internal protected and specified individuals. All disputes relating to right in personam are considered to be amenable to arbitration. What I have stated, my lord, that is not the offense against the public personam. I require public to the enforcement of a mortgage has been held to be right in the for which providing arbitration would not be maintainable. So far this dispute is concerned, it is operates in person. Merely for the reasons that I have alleged the misappropriation during the conduct of the business, that does not mean that for that particular purpose, the matter I may be relegated to the civil court mind. And moreover, my lord, earlier I referred the judgment of 2014 of Swiss Timing Limited, para 24 thereof.
Whether, let us say, supposing there will be a civil suit filed for settlement of the accounts or the claims made, money claims, and there are allegations of fraud. Would it bar a civil court to decide on these issues?
No, no.
As it stands?
No.
Then
But the only
would
question,
it require a civil court to not proceed until the matter gets finally decided by
no,
the criminal court?
no.
The criminal jurisdiction is on whether you have committed an offense and therefore if you
There shall not be any recovery from
there's no question of recovery.
recovery. But the civil court can always decide whether a fraud has been committed and whether this amount is actually misappropriated by the respondent hearing. That can be decided by the civil court.
Correct. So where is the bar for an arbitrator not to foray into
Arbitrator-
this?
Arbitrator's bar is only with regard to the complexity of the situation.
The only judgments you are placing is with reference to Section 8.
Yes.
Then you file a civil case and then Section 8 is pressed that there is an arbitration And there are issues raised that these are allegations of fraud, etc.
Yes,
we discussed.
ISMA is only on section 8.
Section 8.
Yes.
So the court has returned a finding saying that if it is a right in personam, it can be referred to arbitration,
Yes.
subject to the clause being there. All right. We'll come back after at 2.
Much.
Yes.
Item 7.
So we are allowing the petition.
Madam. Well, during this decision, I have also gone through another decision of 3 judges bench of Supreme Court. That also discuss ISM's case, which I have relied. In paragraph.
This is what was clarified. This is
This
where it was unstamped.
ISME was clarified in this also.
No. This interplay clarified this judgment.
Yes.
Where is the clarification regarding ISME?
There is 30, page number 426, paragraph 39. Paragraph 39 onwards. (39.6), 39.7.
This is exactly what we asked you, pair of
Yes,
P.
And the conclusion is that paragraph 50,
Para?
para 50, page 432.
That's right.
That's correct.
Only conviction aspect is to be left.
That is true.
Yes.
My senior is on his leading another court.
Let him come.
Please, Your Lordship. Lordship, may I pay for this matter to be taken up after some time, Your Lordship? After some time, Your Lordship, my senior is engaged before court number 18.
Some other day.
Lordship, there is some urgency on the part of the petitioner. My senior has some submissions to make. Your Lordship, would kindly.
My lord, even we have some instructions and we would like this matter to come up next week, my lord.
Lordship,
Otherwise, my lord, the proceeding has been stayed by this honorable court. They are arranging a stay.
Let it come. What instructions you have?
My lord, instruction is that, my lord, we are preparing an appeal, my lord. It will be likely to be filed today.
Against the order, interim order.
Yes, ma'am. Not this. Yes, my lord.
There is some other writ petition filed.
Lordship, there was a writ petition filed previously to this, after which it was ordered that the disciplinary proceedings need to be completed within a period of 1 month. After which they filed an IA seeking an extension of 3 months. Further, the court granted a period of 1 month from the date of the order of the IA, after which we preferred this writ petition, Your Lordship. On the last occasion, it was ordered by this honorable court that the respondent authorities to bring on record as to what is the current status of the disciplinary proceedings.
But there is a stay already.
There is a stay.
There is a stay to the disciplinary proceedings, Lordship. But as to when it would be
Submission was
completed,
recorded. We'll have it next week.
Next
Lordship,
week, ma'am.
sometime earlier, Lordship.
No, next week. List again on 12th.
Lordship,
Next week, my lord, any day.
on the 14th, Your Lordship.
All right, 14.
Much more.
List on 14. Yes. But Mr. O.P. Bhattil and counsel for the petitioner, Mr. A. or Learned Counsel, appearing for the respondents. This is an application under section 11(6) filed by the petitioner. So the petitioner, then the respondent. at a partnership firm. And a deed of partnership was executed by and between them on the 5th day of August 2020. So the said partnership deed also contained an arbitration clause at clause 22. Stop. Pursuant to the execution of the partnership deed, the petitioner and the respondent carried on their business in terms of the partnership deed. Stop. The subsequently, disputes and differences arose between the petitioner and the respondent. Stop. The petitioner also made certain allegations of where is that notice you had sent? 21 notice.
Notice, my lord. Notice page 27.
27.
43 one notice.
The allegations of misappropriation of fund by the respondent was alleged by the petitioner. So a notice under section 21 was also issued by the petitioner by the notice dated 29/11/2024, calling upon the respondent to appoint an arbitrator. So the notice also referred in detail to the differences and disagreements which have arisen between the petitioner and the respondent. Stop. Did you reply to the notice 29/11, page 32?
No, my lord. I don't reply.
The said notice not being replied to, the present petitioner has approached this court by filing an application under section 11(6) for appointment of an arbitrator under section 11(6) of the Arbitration and Conciliation Act 1996. Per contra, Mr. A. Thor, the counsel representing the respondent, submits that the disputes that this petition is not maintainable as the partnership which was created by virtue of the deed executed by and between the parties was a partnership at will. So Mr. Dhor referred to clause 3 of the said deed and submits that the partnership, as per clause 3, it is the partnership at will. And the partnership shall not dissolve on the death or retirement or exit by any other means or admission of new partners. Stop. He submits that since it was a partnership at will, because of the differences which had arisen between the parties, between the petitioner and the respondent, he had dissolve the partnership. You say you have dissolved.
I have resolved under section 43.
Where is that communication?
That notice is the page 27, my lord.
You had dissolved the partnership under section 43 of the Partnership Act, Indian Partnership Act 1932. To that extent, to that extent, a notice under section 43(1) of the Indian Partnership Act 1932 was also issued by the petitioner, calling upon by the respondent calling upon the petitioner to settle the accounts of the partnership immediately upon receipt of the notice, failing which the respondent shall not be held responsible for financial transactions. So, in reply to the said notice, the petitioner, by his reply dated 26/11/2024, made allegations against the petitioner allegations against the respondent that he had misappropriated funds, causing loss to the firm as well as to the petitioner, and referred to several instances which, according to the petitioner, were incorrect and false statements. Stopped. Petitioner, however, called upon the respondent to come forward and settle the accounts and discharge his liabilities and obligations. Stop. Then, continue. Learned counsel for the respondent therefore submits that the partnership at will was dissolved well prior to the notice issued by the petitioner under Section 21 of the Arbitration and Conciliation Act 1996, referring to the averments made in the writ petition. Mr. Dhor submits that the notice under Section 43 was issued by the respondent on 11/11/2024, to which the petitioner responded by submitting his reply on 26/11/2024. Whereas the notice under Section 21 of the Arbitration and Conciliation Act was issued on 29/11/2024. He therefore submits that prior to issuance of the notice under Section 21 of the Arbitration and Conciliation Act, the partnership being a partnership at will, stood dissolved, and therefore the very plank on which arbitration has been sought for by the petitioner is not available. Stop. He further submits that there is an FIR filed by the petitioner making serious allegations of misappropriation and forgery resorted to by the respondent, and the matter is under investigation, presently under investigation by the concerned authorities. He further submits that the respondent had to seek bail and is currently on bail on orders passed by the court. It is therefore submitted that in view of the allegations of fraud and forgery, it is necessary for the matter to be decided by an appropriate court of law rather than the appropriate court of law. And that being so, the issues which are raised in the present petition are outside the scope of arbitrability, and therefore the matter cannot be referred to for a decision to an arbitrator. Stop. Consequently, the prayer made in this application under section 11(6) should be rejected and the petition be dismissed. Better. Mr. Bhatti, on the other hand, refers to the judgment of the apex court rendered in interplay. Interplay between arbitration and agreements, and so and so. Reported in 2024 6 SCC page 1. Stop. Referring to the said judgment, the learned counsel submits that the constitution bench of the apex court in this judgment had dealt with several aspects regarding the scope of arbitration, arbitrability of issues. Stop. The apex court had clearly held that arbitration agreement has to be treated to be of separate nature from the underlying contract, as it is one of the cornerstones of arbitration law. So he submits by referring to the judgment that the concept of he submits that by referring to the judgment that it is the intention of the parties which will prevail in deciding whether the matter needs to be referred to arbitration. Stop. Referring to the partnership agreement, the counsel for the petitioner submits that there is no dispute that the parties had created the partnership by executing a partnership deed. And arbitration, reference to arbitration is one of the clauses which was agreed to by and between the parties while executing the arbitration agreement. Stop. He therefore submits that besides the contention of the petitioner that the partnership stood dissolved by virtue of the fact that it was a partnership at will, and consequently the arbitration consequently no reference to arbitration can be made, he submits that this argument is fallacious in view of the law laid down by the apex court in the interplay between so and so, so and so. Stop. You are referring to which other judgments? Swiss timings.
Swiss timing.
And Hindustan Petroleum?
Not
City?
Hindustan Petroleum.
Pink City? The learned counsel, in support of his contentions, also presses into service the judgment of the apex court rendered in Swiss Timings Limited versus so-and-so, reported in 2014 6 SCC 677.
There are 24. Especially.
Era?
24.
24.
24. Regarding the criminal offense. There are 24.
Well, Mr. Hor, on the other end, places reliance on the judgment of I.S. Swami. What is it?
My lord, A.I.S. Swami
A.I.S. Swami.
with 2016 10 SCC.
A.I.S. Swami reported in 2016
10 SCC.
10 SCC 386. Referring to this A judgment, Mr. Dhor submits that where there are allegations of serious fraud, then reference to arbitration is not required to be taken recourse to stop these allegations of fraud. It can only be determined by a competent court by a court of competent jurisdiction. Stop. Any other judgments? Your Gujarat judgment.
Gujarat. That is with regard to.
He has also referred to the judgment of Manibhai Shankar Bhai Patel, reported in 1981 SCC online GUJ Gujarat 46, in support of his contentions that, which is the paragraph?
Paragraph 6, my lord.
Paragraph 6. To submit that under section 43, where it is a partnership at will, the firm may be dissolved by any partner by giving notice in writing to all the other partners of his intention to dissolve the firm. Once such a notice is given and the firm is dissolved, as from the date mentioned in the notice, or on the date of dissolution, and if no date is so mentioned, from the date of communication of the said notice. He therefore submits that since it was a partnership at will, and which fact is not disputed by the respondents, by the petitioners, he having issued a notice under section 43(1) of the Partnership Act, the partnership stood dissolved, and thereafter the issuance of a notice under section 21 of the Arbitration and Conciliation Act does not cannot be issued, as the partnership having been dissolved, the partnership agreement will have no effect thereafter, including the clauses of arbitration. Stop. Counsel for the parties have been heard. Pleadings available on record, been carefully produced. The judgments cited have been noted. The core issue raised before this court is whether, in the face of the dissolution of a partnership deal, of a partnership, whether the arbitration clause mentioned in the partnership deal can be severed from the underlying agreement, and parties or any party thereto can be permitted to take recourse to arbitration by virtue of the said clause, para. There is no dispute on the facts that the partnership partnership constituted by the petitioner and the respondent, and on the basis of the partnership deed dated so and so executed by and between them, reveals that it is a partnership at will. Stop. under section 43 of the Indian Partnership Act 1932, where it is a partnership at will, the same may be dissolved by issuance of a partnership, by issuance of a notice to all the partners or the other partners of the partnership stock. In the facts of the case, there is no dispute that the respondent had issued the notice dated 11/11/2024 under section 43(1) of the Indian Partnership Act 1932. So this notice was replied to by the respondent. Sorry, notice was issued by the respondent. So 11/11/24 was issued by the respondent on the petition. Stop. This notice was replied by the petitioner by his communication dated 26/11/24. So therefore, these factual aspects not being disputed by the respondent, it is apparent that under section 43 of the Partnership Act 1932, the partnership at will came to be dissolved upon issuance of the papers by the respondent. Stop. It is also not in dispute that the respondent does not deny the existence of the partnership agreement, including the arbitration clause mentioned in the partnership deed at clause so and so. So there is no averment or submission on behalf of the respondent that the arbitration clause found in the partnership deed was inserted fraudulently by the petitioner without concurrence or knowledge of the respondent. Stop. The only ground urged by the respondent is that where it is a partnership at will and it comes to be dissolved by issuance of a notice under section 43 by operation of law, and that having given effect to whether the partnership deed executed by and between the parties, including the arbitration clause found mentioned therein, will continue to have any effect binding the partners. Stop. In order to answer this question, it is necessary to refer to the judgment, authoritative judgment rendered by the Constitution Bench in interplay between arbitration agreements reported in so and so supra. This judgment inter alia delved into the aspect of separability of arbitration agreement. Stop. The apex court held that the separate nature of an arbitration agreement is the separate nature of the arbitration agreement from the underlying contract is one of the cornerstones of arbitration law. The concept of separability reflects the presumptive intention of the parties to distinguish the underlying contract, which captures the substantive rights and obligations of the parties from an arbitration agreement which provides a procedural framework to resolve the disputes arising out of the underlying contract. This presumption has various consequences in theory and practice, the most important being that an arbitration agreement survives the invalidity or termination of the underlying contract. Relevant paragraphs of the judgment are extracted below. Extract. A careful examination of the judgment reveals that the arbitration agreement is treated to be a separate agreement separate from the underlying agreement in which the arbitration is referred to as a clause or a part of the said contract. Stop. This separability of the arbitration agreement from the underlying contract is essentially determinative on the keeping in view the intention of the parties to resolve the disputes which may have arisen between them out of the underlying contract executed by and between them. Stop. The law, therefore, which governs this aspect is that notwithstanding the termination or invalidity of the underlying agreement, if there was an intention found to have been clearly expressed by the parties to refer any disputes towards arbitration, then the said agreement to refer to arbitration within courts must be treated to be separate from the underlying agreement which contained the arbitration clause. Stop. Coming to the facts of this case, it is seen that even in the notice under Section 43(1) of the Partnership Act 1932, the respondent had called upon the petitioner to settle the accounts. Stop. This notice was replied to by the petitioner by communication dated 26/11/2024, where, while disputing the allegations made by the respondent, the petitioner also called upon the respondent to come forward and settle the accounts. Stop. Therefore, notwithstanding the allegations of fraud or forgery made by the petitioner against the respondent, and which at present is still under investigation, and which fact is not disputed by the parties, the dispute arising between the petitioner and the respondent relates to their business relationship which they had carried on in the form of a partnership supported by the deed of partnership entered by and between the parties dated so and so so and so. Stop. Under such circumstances, it is clearly discernible that at the time when the deed of partnership was executed by and between the petitioner and the respondent, both the parties to the deed of partnership were had consciously agreed upon to refer to arbitration in the event of any disputes and differences arising by and between the parties. Stop. This position is not disputed by the respondent. Stop. The only dispute raised is that in view of the dissolution of the partnership at will by way of a notice under section 43(1) of the Partnership Act 1932, the deed of partnership cannot be enforced, and consequently matter cannot be, the arbitration clause also cannot be enforced. This position, this submission of the respondent cannot be accepted in view of the pronounced law laid down by the apex court in Interplay versus so and so so and so. Stop. The submission of the respondent, therefore, will have to be rejected, and the same is rejected accordingly. Stop. Coming to the question of arbitrability of the issues in view of the allegations and counter allegations made between the parties, alleging fraud and forgery. This aspect of the matter has also been settled by the apex court in Interplay versus so and so, and subsequently decided in subsequently followed in other judgments, as well as the judgment of the apex court rendered in NN Global Marketer Limited, reported in 2021, 4 SCC 379. Stop. In the said matter, the apex court clearly held that all civil and commercial disputes, either contractual or non-contractual, which can be adjudicated upon by civil court in principle, can be adjudicated and resolved through arbitration unless it is excluded expressly by a statute or by necessary implication. Stop. The Arbitration and Conciliation Act 1996 does not exclude any category of disputes as being non-arbitrable. The apex court went on to hold that except certain forms of disputes which are considered to be non-arbitrable, like disputes relating to rights and liabilities which gave arise, copy out para 35 of sequence asset, para 35 of IS Swami judgment. Sequence is that the list is given here. So in the facts of the present case, the allegation of fraud is still under investigation, and no charges have yet been filed against the respondent on the basis of the FIRs lodged by the petitioner. Stop. That apart, the apex court as well as this court has time and again held that the jurisdiction of an arbitrator is fairly wide, and it is open to the arbitrator to even consider the arbitrability of any dispute. Stop. The referral court's jurisdiction in matters of arbitration is extremely limited. Stop. All the referral court is required to do is to examine the existence of a valid arbitration agreement. Stop. Unless the disputes which are sought to be referred to arbitration are specifically excluded under any statute or in the agreement itself, the question of arbitrability of any or all of these disputes is to be left open to be decided by the arbitral tribunal itself. So under such circumstances, this court is of the view that the contentions raised by the respondents are not tenable and the same are therefore rejected. This petition stands allowed. Since the respondent did not respond in time, respond within the period prescribed to the notice issued under Section 21 of the Arbitration and Conciliation Act, the power to appoint an arbitrator the respondents are denuded of their right to appoint an arbitrator, as has been held by the apex court in Dutters, which he has reported in Swings. Stop. Under such circumstances, this court, under the authority given under Section 11 of the Arbitration and Conciliation Act, list arbitrator the list appoints. We can only give you from the list.
Yes, ma'am. May I request His Lordship, Mr. Justice Siyasa, may kindly appeal.
Any objection? But on the last occasion, we found many pending matters. So this will be subject to a declaration given under Section 12.
Yes.
And subject to acceptance by the court.
Yes.
Or else, my lord, M.K. Bhattacharya ji. M.K. Bhattacharya.
Let it be Mr. M.K. Bhattacharya.
All right. This court considers
District Judge.
Ms. Sri M.K. Mrinmoy Kumar Bhattacharya, retired district and session judge Assam, to be appointed as an arbitrator to decide the disputes arising by and between the parties. Stop. This appointment is prospective, subject to the furnishing of the written declaration as required under section 12(1) of the Arbitration and Conciliation Act 1996. Stop. A copy of this order be marked to Sri M.K. Bhattacharya by the registry of the court. Stop. The parties are also permitted to furnish a copy of this order and place it before Sri M.K. Bhattacharya, retired district and session judge. Stop. The matter be listed again for permitting the prospective arbitrator to submit the written declaration before the court. How much time?
Weeks.
22nd. 22nd of August.
But the only thing, the dispute the petitioner has raised in the notice dated 29th of 11/2024, that has been perhaps missed out, madam. That notice for
It is under 21.
no 21, madam.
Ah.
That is dated 29th of 11/2024.
We'll correct it. Notice under 21, section 21, 2911.
There they have raised the allegations only.
Ah. But you
Not
did
in
not
the-
respond.
Not in the reply. In the reply, they have not disputed.
But you did not respond to that.
Yes, that is correct.
This is only on the 11/6.
Yes, that is correct.
Because you did not respond, so therefore there is no
Correct.
question of
Correct.
you hearing you on these allegations now.
Correct. Obliged, madam.
Item 9.
Highly believable.
May this is your lordship. Your lordship, may kindly take up the matter after some time, lordship. We engage in your counsel.
After some time.
Yes, lordship.
After some time.
Much of that.
After some time.
In item so far, item number 9, there is some development is going on.
Initially, my lord, the proposal for my lord, SIU approval of the petitioner.
Let him come.
My lord.
Let him come.
Lordship.
Item 10.
None appears for the petitioner on call. None had appeared for the petitioner on call when the matter was listed last on the earlier dates, namely
Mm-hmm.
14/12/2020, 12/1/2021, 4/2/2021, 15/2/2021, and 16/2/2024. The writ petition accordingly therefore dismissed for non-prosecution. Mr. R. Dhor appears for the
Statement.
state. Which department?
It's PWD, madam.
PWD.
Item 11.
May I please, your lordship?
Arbitration. I'm sorry, mediation.
No, lordship. This is pensionary, release of the pensionary benefits of the petitioner.
Then you
Lord,
refer it
he-
to mediation? No.
No, lordship, it is pending since 2018 and they are saying that the fund is not available and fund cannot be a ground for not allowing the, not releasing the pensionary benefit.
So otherwise they are not disputing your claims.
No. Only the CPF part they have disputed, what has been deducted, yes, and the affidavit is totally silent, without any documents, only mere statements were made. And there is a judgment of the Allahabad High Court where it has been stated that paucity of the fund cannot be a ground to deny the pensionary.
Therefore, we want to refer it to mediation so that you can sort out and the amounts can be released at an early date.
Lordship.
You try, if it works. If it doesn't work, it will come back.
It is pending since 2018.
Therefore, we want to expedite it.
If a direction is given, then
Of course, direction will be given for mediation. It will be placed before the mediation.
no, because
You will also be present along with your client. All right? Refer for mediation. Fixed on 3rd September,
Lordship, a short date may be given because the person is suffering since 2018.
27th August.
Matter.
Item 12.
May plead your lordship. Matter relates to non-payment of retirement benefit, lordship. So after passing the last order, perhaps some amount has received, lordship, but whether whole amount has been received, I have no instruction. So I pray some time, lordship.
Let it go for mediation.
Yes, lordship.
Matter referred to mediation to be listed on 3rd.
Obliged.
3rd September?
Yes, lordship.
Yes.
13.
Yes, your lordship.
Can it be referred to mediation?
Lordship, I don't have any objection. I don't have any objection, lordship.
All right.
Let it go first.
Mediation. 3rd September.
Fourteen.
No. Regarding family pension, we referred
Referred. All right.
16 also.
16 also. Let it be 5th September.
Yes.
16 also.
16 is pension. Return. Okay.
Item 17.
Maybe. But, money has been credited in the joint account of the petitioner's husband and petitioner. But petitioner husband died. Now she filed application before the bank manager to convert the joint account to single account. That has not been persuaded.
So go for mediation.
Yes.
It can be
Short-
resolved.
Short date maybe.
5th September?
Can it be earlier in this month?
In this month.
Malif.
27th
Malif.
August.
Deep law place.
Item 18.
May I please, your lordship. Lordship, the allegation of excess drawal, your lordship, family pension, and it's already a covered case, your lordship, Rafik Masek. Same may be disposed, your lordship.
Who is for the respondent here? Respondent department?
18 PNB Bank, madam. PNB, Punjab National Bank. Yes, one number.
18.
PNB, Punjab National Bank.
Who's for the Punjab National Bank? Who was there earlier?
Mr. Ganguly, A. Ganguly, I think. Huh?
Ganguly. Mr. Ganguly appears.
Ganguly.
A. Ganguly. Let it come up again on next week, 11th.
Lordship, interim may be continued, lordship.
Interim.
Yes, your
All right, interim order we continue.
Oblige, your lordship.
List on 11th.
Standing item 9.
No, development plan, sir. Initially, his case was rejected by finance department. Now it is under consideration. Again, the finance department has seek these documents, lordship.
Have you furnished it?
Lordship, yesterday I have communicated, Lordship, that today the DLR has communicated with the District Commissioner, Sunitpur, Lordship. It took some time, Lordship, take time.
It is being under reconsideration. These documents are sought for.
Why reconsideration, Malab? They appointed us, appointed on the basis of this election. Then they want to say that permission is not given. The committee has been constituted by the Chief Secretary, Finance Secretary, and others, Malab. They have selected us. He has been working since 2017. Mayor Zari Karman. And they said, we will take action against the person who has appointed. What action you have taken against the person, Deputy Commissioner? He has done it on the basis of this election, 2017. Copy sent to the finance, they are sitting tight. Now they are saying consideration. It is Jari Karman.
How long will it take?
Well, from the communication, it appears, well, they are communicating with the district authorities. They will get the information and probably they will then move the finance again. So if they expedite, we can also expedite. So let's say interdepartmental issue now.
I think you need to develop it. You should involve IT instead of physical movement. All these documents can be.
All now records are kept in e-files. But
Then why does it take so
and
much
these
time?
digital signature and all, probably
Everything
now-
is good, but then you are physically asking for the records. It should also be transmitted.
Lots of, but that specific information will have to be there, for that. Maybe by mail or so. Point the officer.
How long will it take?
Probably,
How long,
we
Mr.
will have
Doctor?
to
2 weeks?
expedite.
2 weeks, Lordship.
2 weeks.
Your Lordship may direct that matter may be finalized within 2 weeks.
Yeah.
Whatever is there, they should finalize it within 2 weeks. Then
They
they
have
will
asked
get
for
fixed.
something. What direction do we give now? Unless
Well,
the documents are
on
there.
the basis of this letter, they should finalize it. Why this suffering to this small person, my lord? Jarikar, his father was a Jarikar, appointed on compassionate ground. The government should be, my lord, your lordship knows what the government should be.
No, we can direct them to decide within
Yes.
4 weeks and close the matter. That's
Yes,
not an
yes.
issue.
No,
But
that
question
direct
is
them to
whether
decide and report the matter here.
that we can do. But that 2 weeks will not be possible.
After 2 weeks, Lordship, that may be fixed. Then I'll place the development to take place.
I heard Mr.
Mostly
Giri
the
Das
18
was
months.
18 or 19.
Assisted by Mr. Lokha
19th.
and Mr. S. Doctor appearing for Revenue Department.
Revenue Department.
He submits on instructions that earlier the Finance Department had rejected the case of the petitioner. However, same has been resubmitted and certain relevant documents are sought for. And these documents are in the process of being forwarded to whom? The Finance Department.
Lordship.
Finance
Finance Department asked for.
Finance Department. So he submits that matter be listed again after 2 weeks, by which time he will apprise the court of the status of the queries being met by the administrative department. Mr. D. Gogoi, learned additional AG, appears for the state. For the
19
finance.
minutes. 19
19.
finance.
Finance.
19 minutes. Exactly 2 weeks.
19.
Yes.
Or day after.
Well, let it be 19. At least we'll know whether it has been given or not. Otherwise, even after 3 weeks.
You asked for 2 weeks, so we had given 2 weeks, so it can be on 20 or 21.
Well,
Lordship,
21.
21. Lordship.
21.
Yes.
Lordship.
List on 21.
Obla.
As agreed to by the parties.
For hearing item 21.
Lordship, hearing is already concluded in this matter. Written arguments are also submitted before the court, Lordship.
All right, we heard reserve.
Yes.
Obliged, Lordship.
That's all.
Can clearly show.
Maybe words. That the matter relates to my lord family pension, my lord. The last occasion, my lord, the record has been called for, my lord.
See, the records have been received, and basically the record is in connection with the service book of the petitioner. But
Husband of the petitioner.
yes, sorry, husband of the petitioner. But the issue here is, Lordship, distribution of the family pension between the petitioner, one of the wife, and the respondent number 9, who is also the wife of this thing, of the government employees, government servant person. Now, Lordship, we have filed one affidavit. In our affidavit, we have said there is an order by the Lok Adalat, Lordship, saying that you distribute the family pension equally. So we are saying that we have no problem in distributing the family pension equally by following the Lok Adalat order. Now, what has happened, Lordship? Accountant General has this thing, they issued one order, no? The order that the whole family pension to be given to respondent number 9. So it is basically the Accountant General, AG, who is required to answer, because otherwise I have no difficulty in giving the family pension to both equally. So this record I have received, but this is a service book. I think service book has nothing to do here.
Accountant General has rightly said so, because the family pension is to be released to the
Housewife.
to the family defined in the pension rules.
But there is a Lordship Lok Adalat, permanent Lok Adalat of Lakhimpur, Lordship.
It will have to be interfered with. How can it be this divided equally?
Basically, Lordship, I am not going into all this, Lordship, because here it is a permanent Lok Adalat Lakhimpur. The answering, however, cannot comment upon the finding and order of the learned permanent Lok Adalat Lakhimpur, except for the fact that pensionary benefit of late Tilak Chandra Khan, retired supervisor Kanango, a government servant, was directed to be equal shared between both the wives and their
Where
children.
is the order of the Lok Adalat?
My lord, that lordship will find that page 31. Page 13.
And and also this Lok Adalat order hold the power of civil court, Lordship. You have to civil court order, Lordship.
That division, my lord, on the basis of petition filed by the my lord, respondent number 9. The my lord, record has been called for only to verify whether there is any nomination.
This is the succession certificate.
Yes, succession certificate.
The succession is given by Lok Adalat.
Because this was filed in my lord before the district judge, my lord, and that was my lord has been referred to the Lok Adalat, and the Lok Adalat has my lord passed that order 8/5/2014.
Yes, petitioner and us. Yes, petitioner and her son, Midul Hazarika Khan, will get 50% of the entire amount, and opposite party number 1 and 3 and 4 will get other 50%, and also the interest accrued thereon. Divide কৰি দিছে।
Where is the amendment to the pension rules? Amendments. The pensioner amendment get a due.
The record has been called for to verify, my lord, whether there is any nomination in the service book of my husband of the my lord petitioner. If there is
Is there any nomination?
If there is any nomination, then 137 will my lord apply.
Let me check. ইয়াত নাথাকিব এখন পেঞ্চনৰ বহি এখন চাৰ্ভিচ বহি
You examine and come back later. Examine, come back later.
Item 23.
May I please, Lordship? Lordship, in this case, Lordship, sir, earlier heard the matter for some time, Lordship. In this case, the respondent pursuant to ex parte inquiry proceeding, Lordship, the petitioner was released from service, Lordship, by impugn order dated 7/12/2020, Lordship. That is page 52.
বিচাৰি লাগিব ন বিচাৰি লাগিব
ফিচাৰী মানে আপোনালোকে হেৰি কৰিছে নেকি?
মানিটো আমাৰ এফিডেভিট আছে সেইটো এফএলও হিচাপে
Where is the inquiry report?
Lordship. Page 51. Before that, Lordship, page 71 is the Constitution of Inquiry Committee, Lordship, on 11 August 2020, whereas the inquiry report was submitted on the 13 August 2020. 11, page 71, Lordship, Constitution of Inquiry Committee, on 11 August 2020.
Page number?
71.
71.
After 2 days, Lordship, inquiry report was submitted.
Not 2 days, 6 days.
13 August, Lordship. Inquiry report, Lordship, today on 13 August 2020. Lordship.
2 days.
Okay, the petitioner was, Lordship, what happened, Lordship, in this case? The petitioner was promoted on 11 July 2016, page 36, Lordship. And he was posted at Research Officer Arta Amranga, Lordship, Rani side, Lordship. And accordingly, the petitioner has joined. And thereafter, during that posting, Lordship, subsequently, the 11th of September 2019, Lordship, the circle officer, dispute officer has appointed him as deputation, Lordship, as a field officer, Lordship. Page 37.
Yes.
And in that order, Lordship, that duties and responsibility of the BLOs is prescribed, Lordship. Page 37.
Yes.
Pursuant to the instruction contained in letter number.
Now in this inquiry, you want to say no notice was given.
No notice was given. And Lordship, what happened in this case, Lordship? The main ground of the respondent side
is that the circle officer not is a competent officer also to appoint the appoint the petitioner on deputation also. Whereas the deputy commissioner office has now pursuant to this on our court's order file affidavit confirming that he is the authorized officer. So the very ground, Lordship, where on the hood, on that basis the petitioner was dismissed from the service, that the authorized officer has not appointed him on deputation, Lordship, as the deputation, Lordship. But now the deputy commissioner office has confirmed that he is the authorized officer. If Lordship take up their affidavit, Lordship. Affidavit filed by the respondent full. Paragraph 6. That with regard to the statement made in paragraph numbers 8, 9, and 10 of the petition, the deponent states that the purported letter dated 11/9/2019, because Lordship, if Lordship peruse that later, Lordship, we have annexed in our petition, page 45.
No, whether notice was served on you or not.
No, Lordship. No notice was served.
No notice.
No notice was served.
Yes, Mr. Borwell. Whether notice was served prior to the inquiry.
In the affidavit, Lordship, in the affidavit, in regard to the Lordship, that part, Lordship, it's not.
Being an officer of the court, Lordship, my duty is that, Lordship, to point out, Lordship, because now the learned fingerprint is appearing for the both deputy commissioner as well as the fishery department.
No, fishery, I am not appearing.
But
Fishery, I am not appearing. That's why I am only appearing for the deputy commissioner, and it has been stated that during that period you are being working as FLO, and you are being appointed under the office, Lordship.
File our affidavit in our favor.
No,
Deputy commissioner officers.
no, it's a very fair affidavit. But if I
Lordship, take up the affidavit filed by the respondent 5, Lordship. They have clarified that point, Lordship, in paragraph 4.
So basically, circle officer appoint the BLO, Lordship, and BLO are later designated as FLO. He is a FLO. So appointing authority is circle officer. The DROs appoints the BLOs under the jurisdiction in that matter. The circle officer appointed him.
You are challenging what here?
Termination letter, Lordship. Because, Lordship, at that point of time, I was terminated on the ground that I was unauthorizedly absent, Lordship, from the duty. Whereas that point of time, I was appointed as the BLO,
Where is the termination order?
page 52.
Officially,
52.
Yes, sir.
Do you have any records with you?
no, Lordship, Fishery, I am not appearing, Lordship. Panjal Sharma is appearing. That is the.
Where is
case.
where is the standing counsel?
See, I have informed in the group, Lordship. I am not able to find him, Lordship.
Earlier, Lordship, government advocate appeared for.
No, one point of time, government appeared, Lordship, but after that, Lordship, it has been bifurcated.
Well, call him, Fishery standing counsel. Let us wait. Fishery standing counsel.
Item 24.
May I please, Lord? Here in this case, my lord, petitioners were premature retirement, my lord. Since, my lord, in their service book, my lord, date of birth is correctly written, but during the regularization process, my lord, their date of birth is incorrectly recorded, my lord. That's why they have been in the superannuation, my lord, in the year 2017 and 18, my lord.
17,
department
18,
have-
you retired, superannuated.
Department have retired me, my lord.
17, 17 and 18.
17 and 18, my lord, respectively. Because, my lord, in the regularization, when 2005, my lord,
Well, but you have filed it in 2022.
my lord, 2019, I have first writ petition filed, but due to some mistakes, my lord, that's why I have put withdraw and I have also annexed the order, my lord.
Now, then again, correction took you 3 years.
2019, no, my lord, order passed on, my lord, to 29/11/2020. That is at page 63, your lordship, ma'am. Page 62 in my writ petition. By that time, department also submitted the affidavit, my lord. During hearing, my lord, in typographical mistake due to, my lord, that's why monocolor copy. It is noticed the petitioner claims legal right to claim in correction of report on page 22 annexed to of the writ
You
petition.
see page 63, the order.
My lord, I am reading that. 29/11/2022, my daughter dated. It is noted the petitioner claims a legal right for claiming correction of date of birth based on page 22 annexed 2 of the to the writ petition, where the date of birth of the petitioner is shown and stated to be copy of the service record of the petitioner. But when the vernacular copy of the service record is examined, it is noticed that the information is not available there, meaning thereby that the translated copy of the service record contains information beyond what is available in the vernacular version, and that the additional information is thought to be made on the basis of make a legal claim in the writ petition. In the circumstance, petitioner seeks withdraw this writ petition, but however, liberty is paid for to file any other appropriate application if so advised. In view of the above, writ petition stands closed as withdrawn. Liberty is paid for granted, my lord. Because that's why, my lord, we have again approached, my lord, with the department's.
No,
affidavit,
that is
my
all
lord.
right. Show us this is correct. Vernacular and translated, what happened to that? Vernacular and translated?
Page 25, my lord. That is the age date, my lord, and along with the original copy at page 26, my lord. And that document is also relied on by the department also, my lord. And I have also annexed this affidavit also. family pension related may be subject to be. New pension, old pension, different in W. যদি family pension में different country 17, 18, 19, 143. এতে দিয়ে প্রথম
Where is the discrepancy here, Mr. Nayak?
In the earlier petition discrepancies were there, and that is why he withdrawn the writ petition and this writ petition was filed.
No.
In the present petition,
Earlier writ petition, there was a discrepancy found in the translated copy.
yes,
Now this is, when page 25 is not that translated copy, it's a new one.
That's why, my lord.
It's a new one.
according to him, it's a correct translation.
Subsequently, I have corrected, my lord.
What was corrected?
Date was corrected, my lord. Since, my lord, it's a copy paste, my lord, since two petitioners are there. That's why, my lord, that mistake is happened, my lord.
Yes, yes.
All right.
And departments also submitted the service record also, my lord, in their affidavit, my lord.
Now, after retirement, how the date can be corrected now?
And in fact, the
Hello,
case
Dave.
was then taken by the finance department. In fact, a proposal was moved before the finance department in the year 1919. So as per the FRSR, it is required prior to, prior to 3 years before.
No, my lord, that is not correct, my lord. Since, my lord, they were regularized in the year 2005, my lord. Subsequently, department found that their date of birth, some other, although along with some other persons, my lord, date of birth names were incorrectly recorded, my lord. I have also annexed this document. Your lordship may found at page 35, my lord. Here, my lord, department have referred the matter to the additional chief engineer, my lord, by the executive engineer. That, my with reference to the subject, I have the honor to submit here with report of correction of modification of names, date of birth. Page 35, my lord.
Yes.
With correction of modification names, date of birth, date of engagement, Indians were already regularized work charge, master rule workers by number such and such, 39/2005. With reference to the subject cited, I have to honor to submit here with the report of correction, report for correction, modification of names, date of birth, date of engagement, etc. Names and date of birth, date of engagement, etc. Work charge and master rule workers who has been regularized by number dated 39/2005 as per pro forma along with necessary documents, documentary proofs for favor of fine perusal. That is the first communication by the department. We have not approached, my lord, but department has the of their own, my lord, approached before the additional chief engineer with correct. That is also, my lord, I have annexed, my lord, that is at page 37. Your lordship may found. This is the type copy, my lord, and second page is 838, my lord, is the original copy, my lord. That proposal, my lord, both the petitioners were sent, my lord, and their date of birth is shown as 28/2/1972 and 31/10/1970. Subsequently, department have conducted a inquiry, my lord, through Deputy Commissioner Nwagao, my lord, and established the fact that their date of birth is 28/2/1972 and 31/10/1970. That's why, my lord, department have sent the proposal to the finance department, but finance department have in their inability to approve the matter, my lord. That's why, my lord, I have before your lordship, my lord. Page 93, I have annexed this, my lord. That is letter dated 20th June 2019, last page, my lord.
No, who detected the discrepancy?
Department, my lord.
How?
Department in their affidavit, my lord, your lordship may found it at page 96, your lordship, internal page. Lordship got it. Para 5, my lord. That with regard to the statement made in paragraph 5 of the writ petition, the answering deponent begs to state that in regulation letter, some anomalies regarding the date of birth and names of few longs of employees were found and necessary correspondences has been made to the government for correction and modification of the department, date of birth as well as name by office letter dated 2053 dated 28/5/2008, which I have annexed, my lord. In response to the government letter CE such and such 13/2008, may be stated that the most of the records of the office, including records of employees who are completely damaged during flood occurred and at Jaklamanda on 13/8/2017. At para 6, my lord, that with regard to the statement made in paragraph 6 of the writ petition answering deponent begs to state that in continuation of the office letter 2053-28/5/2008, one proposal for correction and modification of date of birth and name of the incumbent has been sent to the additional chief engineer P. Assam, Chanmari, Guwahati by office letter dated 8243 dated 24/12/2015. In the meantime, Under Secretary to the Government of Assam, Pedagogy Audit Branch, Dispur, Guwahati, sent a letter to this office by letter dated so and so, asking a report from District Magistrate. Accordingly, necessary correspondence were made from this and to the Deputy Commissioner Nwagao regarding the matter. The Deputy Commissioner Nwagao had submitted verification report by number such and such 1/12/2018, and same were submitted to the Undersecretary Audit Branch by this office letter dated such as 27/12/2008. Thereafter, Undersecretary to the Government of Assam Pedagogy Branch, Dispur, Guwahati once again issued a letter to this office by 4/3/2019, asking point-wise comments to this office, quoting reference to the Finance Department. Reply has furnished from this and by this office number such and such 4/4/2000. Finally, Undersecretary Audit has informed this office that Finance Department declares their inability for correction of the date of birth of the incumbent by letter dated 26/2019.
So had it been corrected, then when would you have retired?
My lord, I have not, in fact, my lord, we are going, but we have not been received any salary, my lord. And in the meantime, one of the petitioner has expired, my lord. And his legal hairs
You are
also.
going, where are you going? Where are you going?
My lord, in the executive engineer's office, my lord. Your lordship may call for the also.
If
from
they are
the-
allowed lordship, they will continue till 2030 and 2032. If their correction is allowed.
Oh, but this was initiated by the office.
Yes, lordship, but in the year 2015 only. And it was not at the behest of the petitioner, the department itself. So petitioner has no grievance so far as his date of birth is concerned. That will be another way of looking at the matter, lordship.
My lord, I have
So
not
it
been
was
received any
not
salary. my lord.
initiated.
But if the department has initiated, means that there is some error.
It initiated in the year 2015. A notification was issued in the year 2006 itself. If any discrepancies are there in the regularization order, then that may be corrected with the permission of the.
That was committed.
So Finance Department took the stand that your proposal reached the Finance Department in the year 2019 itself only. Accordingly, it is as it is not as per the provisions of FRSR, Finance Department regulated. That is the basic law. So in this case, lordship, my difficulty will be stand of both the departments are different, lordship. They are one department has taken one view, another department has taken another view.
So you represent one department. Why are you representing two?
Today, lordship, I only in the morning, lordship, I went through the file, lordship. Otherwise, also this matter will require some time, lordship. Readings are complete, lordship will hear this matter.
This matter listed for hearing only.
Yes, madam. Today for hearing.
That is
madam.
there.
If my learned friend has problem, my lord, in that case, your lordship may fix it next week, my lord. And I will satisfy your lordship, my lord, in this case.
After 1 week.
My lord, the date may be fixed.
Made by the on a hearing date, on a request made by the learned additional review.
Take it, please. 14th, my lord.
After that.
On 19th, my lord.
Some date will be fixed by the registry on a hearing date.
My lord, please, my lord. Just since my lord, these people has not been received any salary, my lord, last 5 years, my lord. Your lordship kindly.
Salary, the court is not the reason for that.
That's why, my lord, I am praying for early.
We are giving you an early date. It is a 22 matter. We are giving you early dates. We fix a date. We'll fix the date. Will be given by the court master after 1 week date for a delivery.
Obliged, my lord.
Timing item 22.
My lord, records, my lord, only the service books are there, my lord. And my lord, so far the, my lord, pension papers are concerned, it is not available, my lord. Because, my lord, in the affidavit, my lord, the department, that is the office of the deputy commissioner, has, my lord, forwarded the pension papers, including my name, my lord. So there may be, my lord, some records.
Who will have the pension papers?
No, perhaps because the last order was passed by the accountant general. So perhaps the it will be with the accountant general, huh? One more thing.
Good idea, I know.
Departmental logo thing. Departmental logo.
Yes.
This will be the department, Your Lordship. This letter is with respect to we sought certain clarification from the department
In page
regarding
49, my lord, last line, my lord. Petitioner's names was included for the purpose of family pension in the revised form number 10 and forwarded to the Accountant General Office, Guwahati, for necessary action by way of letter dated 19/3/15.
Where are the amendments to the pension rules? You don't have. You get the amendments to the pension rules.
The records, my lord, maybe, my lord, for otherwise, my lord.
The records, we don't know whether the records will come or not come. There's so many opportunities being granted for records, it is not being produced. Nobody knows where are the pension records.
Lordship, may I get one call to my office?
You call or visit them is up to you. We'll call up next week.
Lordship.
Next week. On the request made by the council for the respondents.
That observation may be reflected.
What observation?
Regarding record, my lord, otherwise,
We'll see.
otherwise they will not take any steps, my lord, that's why.
I think it is time for us to call the officers to the court. Because the councils are at a loss. You don't know who's holding what records. Nobody knows.
Let me give a try. Let me write a letter singing for the process.
You are the officers of the court. You must carry out the orders. Otherwise, what kind of assistance are you giving?
It has been sent to the accountant general to faster.
Don't make submissions without any basis. You find out from the records why it is being sent, who has received it.
The answering deponent is the family pension of county so and so. Right, accountant general letter number so and so, FPPO in the.
So then it will come back if the PPO has been PPO issued.
No.
Then you inform the court on the next step.
No, sir. No.
After 1 week.
That's it. Obliged, Your Lordship. Item 26.
None appears passed over.
27.
May I please, Your Honor? This case, Your Honor, the petitioner is a permanent employee of respondent number 1, Assam Polyester Organization Limited, Lordship. And it is that unit is not working now. And petitioner was working as an accounts officer there, Lordship. And he was performing his duty diligently. and he worked there for approximately 10 years. So after the closure of the mill, he has also performed his duties for a period of 6 months. But after that, what happened? He was asked to report to duty to Rongia in the factory, but he was not received salary for many months, and that is why he would not travel to Rongia on a day-to-day basis, because at that time he didn't have any money. And he also reported the same to the MD also, and he said that he has to look for an alternate job because to survive, he had to feed his family and all. And he has also issued a character certificate by the MD. That is part of record, your lordship. Now, later he came to know that a VRS scheme has been rolled out, and some of the employees have already received some part of the VRS as provisioned by the state of Assam. But he was not given the opportunity. So later he submitted representation before the registrar and also other officials, but there was no replies to his representation of lordship. Then being forced, he preferred this, and the petitioner preferred this repetition. And respondent side has submitted affidavit opposition saying that the petitioner has not reported to duty, and it was a duty as an accounts officer and to complete the balance sheet. And as such, he should not, he has been debarred from the benefit of VS. But till that, your lordship, there has not been any order stating that the petitioner has been debarred. No so-called notice has been given to him saying that his VRS will not be given to him. No disciplinary action has been taken. It is a totally arbitrary order that has been passed by the board. And even before giving him a so-called notice, a board had, if you lordship peruse the affidavit in opposition in filed by the respondent, your lordship, in page number 49. So in page number 49A, it is saying that salary of Mohammed Abdul Taleb, account officer who worked at head office, will be kept under hold as he is not keen to extend help to the mill authority and has not come forward to complete the annual accounting job for the period FY 16-17 and FY 17-18 in spite of several telephonic requests as well as wide letter dated 15/3/2018 from the mill authority. It may be mentioned that Mohammed Taleb is conversant with account keeping of the mill as he was maintaining the records related to accounts. So this board resolutions dated 23rd September 2018. And after 9 months, a so-called notice was given to the petitioner. That so-called notice is, your lordship, in page number 45.
What is the status of the VRS now?
Lordship, out of the total amount, 12 CR has already been released and the remaining amount will be released within this financial year.
Are there any persons, the VRS, who are to be allotted VRS is already
That
decided?
has already been decided, your lordship.
He has been excluded.
He has been excluded.
Why?
Lordship, reason behind that is, lordship, he was found, not found on duty, your lordship. A so-called notice has been issued. And apart from that, your lordship, here, I do appear for the cooperation department. But here the petitioner, he is an employee under the board of directors. He's an employee of the cooperative society. Now, the question which arises is whether this writ petition is maintainable because the recessor no judgment will come into force in that case, your lordship.
What is that judgment?
It says that he being an employee of a cooperative society, he needs to file a civil suit to raise his claim, your lordship.
What is the status of the society? Is it
It is under liquidation, your lordship.
liquidation? Where is that judgment?
Lordship, it's 1993 1 GLR 184. Your lordship.
Yes.
Soft copy, yes, sir. Now, your lordship, the problem which we faces here is that the decision has been taken by the then board that his name was not included in the VRS list, your lordship. And whatever list has been provided to the department, that has been processed according to the report received from the chartered accountant firm, your lordship. Now, in the list itself, his name was not included, your lordship. And that decision has been unanimously taken in the board meetings by the then board, your lordship.
But that decision was never communicated to your lordship. So if the decision is not communicated, whether that is a valid order in law or not.
And moreover, in his affidavit in reply, he have clearly stated that due to his financial
So
crisis.
assuming it is not a valid order, where do you go now? Your company, your corporation is in liquidation.
Yes, he's on a liquidation, your lordship.
Who will pass that order of including your name in VRS?
Your lordship, when and this present writ petition was filed, at time it was not in a liquidation.
All right, today it is.
Your lordship, yes.
Who will pass that order? The court. We
Uh,
can't pass that order.
But lordship, in that case, the liquidator may be directed to.
Is
maybe
he a
to the-
party?
So they may.
Is the liquidator a party?
Is liquidator is also a party, your lordship.
Who's appearing for the liquidator?
Liquidator, he'll be a departmental officer, so lordship, I can represent him.
What is the stage of liquidation?
Lordship,
Whether
the
you
last-
can consider the claims of the workers?
Lordship, I also like to submit one office memorandum dated 15 May 2000, your lordship. Wherein the grounds of denying VRS are given, your lordship. It is stated this VRS should not be given to those employees / workers against whom disciplinary proceedings, prosecution sanction, court cases, or any other case like suspension, dismissal, etc. is pending settlement. But in this case, there no such action against the petition, your lordship. So there also, I am eligible for the VRS, your lordship. Serial number 5, your lordship.
Yes.
in that case, your lordship, he may approach the liquidator.
You tell us what is the stage of liquidation?
Lordship, that I have to take instruction, because last instruction which I have received in respect of the other cases, liquidation process has started.
All right, day after tomorrow, we'll
Lordship,
get it.
lordship,
Day after tomorrow,
lordship.
raise this matter again on Thursday. Enabling the Standing Council Cooperation Department to obtain the status of the process of liquidation.
Obliged.
Of which the cooperative society is presently under. Matter be listed on Thursday.
Lordship. Obliged, lordship.
Mr. So for the petition, and so for the respondent.
Handling item 23.
Yes.
Lordship, I have one friend, I was not privy to this matter, lordship. I will file affidavit, lordship. Only one officer has filed Sanjeev Chaudhary of some district level. From the department side, we will file affidavit.
Who undertook the inquiry?
Lordship,
Fishery Department.
Fisher department. It is, the affidavit is not from the department, lordship. One officer, I've just now gone through it, lordship. I was not there initially, lordship. Let a copy, I will take copy from him.
Copy not furnished.
Lordship, we have to, no, actually earlier department was doing, no? Maybe recently. This affidavit was filed, lordship.
Heard Mr. P. Kodita and Mr. P. Sharma. And who else appears? Mr. Sharma appears on behalf of the Fishery Department.
Lordship.
He submits that he does not have the specific instructions in the matter and therefore seeks liberty to obtain the complete instructions with regard to the inquiry proceedings undertaken by the Fishery Department in respect of the writ petitioner. It brings for 2 weeks' time.
Let give it 3 weeks, lordship.
3 weeks.
In 2020, lordship, the petitioner. I'm there, lordship. You will get a relief. I'll make it happen, all the instructions.
And you want what copies? What copies you want?
Petition copies.
I will provide all
All the copies, I will give, need not record.
The counsel for the petitioner undertakes to provide sufficient extra copies of the petition to Mr. P. Sharma. List after 3 weeks.
Only, my prayer, Lordship, we fix a date also, after 3 weeks.
After 3 weeks,
Oh, no issue.
28,
Highly obliged.
Hello.
28.
Obliged, sir.
Item 28.
May it please your lordship, my senior is having some personal difficulty. If you may kindly adjourn the matter for the day.
On the request made on behalf of the council, matter stands deferred to be listed next week.
Any day after 14.
You said he is having difficulty for a day. Yes or no?
Yes.
Yes, only for the day.
Sure.
So we are listing it next week. Yes. Mr. G. Bora. D.
Okay.
Bora for the respondent.
Item 30. May I please, Your Lordship? Well, pursuant to departmental proceeding, punishment is imposed upon the petitioner for reduction of 3 days pay. And final order, Lordship may find it page 71 onwards.
You filed appeal. Appeal filed.
Yes, well, appeal was rejected. Accordingly, revision was also rejected.
Where is the order?
Lordship, final order is from 71 onwards, my lord.
71.
Yes, well. Two charges brought against the petitioner, my lord.
Where is the inquiry report?
Lordship, 44 onwards, page.
Today I need some little recommendation, but I missed the lordship file. And name was not reflected in this case. Otherwise, record also call for record I have received lordship. Both the records I have received lordship.
Yet you missed the matter.
Lordship?
Yet you missed the matter.
Lordship. Origin record lordship, long back I have received lordship. Origin record, both review records as well as lordship, origin record, two records. Any day lordship.
Tomorrow,
Next week?
next hour difficult, after 2 weeks.
All right, after 2 weeks,
Lordship.
as prayed for by the council for the parties. List after 2 weeks.
Well, one date. No.
So we can't give you dates like
Lordship.
this. You make a mention, we'll fix
My
it.
lord. Oblige.
There's no point giving dates if you're praying for time.
Lordship.
Yes.
Items 31 and 32.
On behalf of Mr. J.I. Burvia, Lordship, matter may be affirmed for the day.
Hmm?
Next week, any day matter may be taken.
Next week, all right, on the request made by, on behalf of Mr. J. Gorgoya, matter stands deferred to be listed out. 1 week.
Oblige.
33.
May I please, your lordship? I would like to request to adjourn the matter for the next Thursday, this week,
This week,
sir.
not this week, next week.
Next, no, this week, Thursday, date 7.
Hmm?
Date 7, for date 7.
Or
She wants, my lord, the matter
On
is 6 or
7th.
7.
7 is not possible. You have it on 12th or 14th,
Fine.
whatever is good for you. 7 not possible. Next week. Matter be listed next week. Mr. Ardor for the respondents.
Item 25.
You. Yes. Yes.
Lordship, I think. Here. Mr. J. Roy, Senior Advocate J. Roy is not available today, but his arguments are completed.
Whose arguments?
Senior Advocate, Lordship, Mr. Senior Advocate, Mr. J. Roy is appearing in this matter. His arguments are completed for this matter. It's their
So-
turn,
Arguments are completed.
as per my instructions was.
We don't recollect.
Arguments are completed.
No.
No, part heard, matter is part.
How is it completed? Yes. Yes, Mr. Counsel?
Lordship.
Yes.
Yes, Your Lordship. Actually, my senior is also there, Miss Kumari. But I just want to apprise Your Lordship, the pleadings in this matter were complete in the year 2023, in the end of the year 2023. Now, in 2025, somewhere in June, they have filed a supplementary affidavit without the leave of this court. So I'm highly objecting that supplementary affidavit, Your Lordship, at the preliminary stage, because that should not be taken on record. That is why I have not filed any response to that supplementary as well, because the matter is at advanced stage, part heard matter. Without the leave, they are filing this affidavit, 300 pages affidavit.
Where is that affidavit? Is it filed?
Yes, Your Lordship. Yes, Your Lordship, it is filed.
I don't know. We have been served.
Yes, Your Lordship.
When was it filed?
And nowhere it is recorded in the order as well, Your Lordship, subsequent to the filing of this affidavit and previously before filing this.
What affidavit is this? Additional affidavit.
Yes, Your Lordship.
When was it filed?
The 2nd of June, Your Lordship.
There is an order on 3rd of June when Liberty was sought for to file an affidavit.
It is not audible. Lordship, on 3rd June.
3rd of June.
Yeah, they.
But you filed
requested
it on
to
2nd?
file. On 3rd June, Your Lordship, they requested that they'll reply to the affidavit.
No, kindly allow me to apprise Your Lordship. 2nd of June, they have filed this affidavit. So the matter appeared on 3rd of June. I was not there. Some junior was there, Mr. Bora. If Your Lordship can see the order.
Yeah.
And he don't know and he has taken leave to file the response. But that is highly objectionable. There was no leave. Only with my junior was there who has sought leave for filing of response. But this affidavit has not been taken on record. And this has not been filed with taking any leave.
Yes. What do you say?
Lordship, it may be taken up next week. The matter may be taken up next week.
When were the arguments complete? You said the arguments were complete when?
Lordship, I'm not I'm not aware of that. Exactly when the arguments were coming.
Partly it was heard.
Yes, you are Mr.
Rohit Kesri.
Huh?
Rohit Keshri,
Kesri.
Rohit Keshri, and Madam Kumari.
Let us have a fixed date for hearing this matter.
Some convenient date may kindly be fixed. So
Yes, Your Lordship.
9th of September.
9th of September, Mr. It is convenient for you? For them also it is required their convenience.
List on 9th of September.
Okay.
As agreed to.
9th of September.
Your Lordship, can it be 11th, Your Lordship, instead of 9th? Instead of 9th, 11th or 12th? As per your Lordship diary permit.
All right, 11th of September.
Much obliged, Your Lordship.
By the council for the parties.
Much obliged, Your Lordship.